ಬರ್ತಾರೆ ಬರ್ತಾರೆ ನೀವು ಏನು
ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ಆನ್ಲೈನ್
Vacancy is this work, the matter pertains to transfer. But the respondent work, he has overstayed in the same place. But I was waiting for posting what I was given posting. And the respondent question before the tribunal wrote the transfer.
We'll give you a listing as soon as is possible. Because the lists on, let's see, please hand it over as soon as possible.
This is election transfer, madam. The KET allowed the application, madam, that have been subsequent appointment is unavailable. In the very, in this matter, madam, the KET has taken difference and this is an application. The party won't, madam.
As soon as possible. Which is the matter with regard to?
Not singular request, fresh transfer. May I request, not Tuesday, my lord. Monday, SKT may not come. Tuesday, my lord.
Tuesday or Wednesday, it will come.
Wednesday.
Let's see.
Any mentioning? List 1. Page 1, seal number 1 to 3. Page 2, seal number 4 to 11. Page 3, 12 to 14. Page 4, 15 and 16.
Any date or that.
Yes, Not-
21st.
not the next week, the week after.
Yes,
Yes,
21st, okay.
but entry model maybe.
of course, will remain in force.
Page 5, 17 to 23. Page 6, 24 to 28. List 1, hearing on IA, seal number 1, Vikram Balaj.
This is that option matter where she has been reverted from the post of assistant executive engineer.
Question is only whether she can be promoted without disturbing seniority of anybody else. The reversion is from the post of,
Assistant executive engineer grade 1. So far as the executive engineer is concerned, my lord, there are 33 posts. Now 29 have been screened and they have been given a postings last Friday. So therefore, DPC, my lord, my name was there, it got deleted subsequently. So therefore, it is up to the DPC to consider my case so far as executive engineer concerned, if the vacancies are available. That's it.
Issue relates to not the transfer on her request to the care of assistant engineer.
correct.
So first, her seniority in the assistant engineer has to be determined below the respondent.
Now she's been reverted to the post of assistant engineer.
Yes.
Hmm.
Now she is in the care of assistant engineer.
Hmm.
Now her seniority has to be determined in the care of assistant engineer below me. Because it is on her request, not the.
Pending,
Subsequently, if she.
pending these proceedings, she is willing to take her seniority below you.
Yes.
Pending the proceedings, without prejudice to her
Yeah.
contentions. Below you in the cadre of assistant engineer. She is eligible for promotion as assistant executive engineer. Even if she is below you, it can be considered as a contention.
You have already been promoted as assistant executive engineer. Even if the assistant executive engineer ranking, my lord, she has to place below us.
Correct. As of now, it will be.
Yes.
That is the only prayer that is being made. That she'll be considered for, and further promotions. Have you been further promoted as executive engineers?
We
No.
have been promoted as executive engineers because we were.
Last week they have been
Now-
promoted.
Now, by virtue of the redoing of the entire seniority list, not she
According to them, Lord, she is not eligible for promotion as an executive.
Let it be
It is
considered.
for them to decide.
Let it be considered.
Yes.
Let the promotion as executive engineer be considered without reference, without disturbing the seniority of the respondents for the time being. If there is a vacancy and if she is otherwise eligible, what stands in the way
They
of
say
her
that
being?
if she is not qualified as
Let
a.
it- Let it be considered. That is correct.
My lord, 31, in fact, I have a material. 31 people, my lord, the names have been screamed, placed before the deficit.
Let us,
I am
the time
agreeable,
being.
my lord. I am, only one small request is 31 people, my lords, have been screened. Now, first list was around 25, then 29 people have been further promoted. Now, as on today,
question would be, if you are placed below the contesting respondents as assistant executive engineer, then would you be eligible to be included in the zone of selection for the post of executive engineer?
execute, that has to be considered by the respondent.
Correct. For assistant executive engineer, she will be now be promoted for the,
No. 2021.
whatever that be. Now, she is eligible for promotion as assistant executive engineer. Grant her that promotion and without prejudice to her contentions in the writ petition. If, as a matter of fact, the question of promotion, the eligibility to the post of executive engineer, her earlier service will probably have to be considered. That is another question. Whatever that be, her request for consideration of her promotion as executive engineer, that also take it up and
Even considered for.
She has been already promoted on 3/1/2024.
that was
Because of the tribunal order, I have been reverted.
heard the learned counsel, learned senior counsel appearing for the petitioner, the learned government advocate appearing for the official respondents, as well as learned counsel appearing for the contesting party private respondents. It is submitted by the learned counsel, senior counsel appearing for the petitioner, that the petitioner had been promoted to the post of
Assistant Executive Engineer
by
on 3/1/2024
3/1/24.
with effect from 17/6/2021. That is the date on which the respondents have been promoted.
With effect from 17, just a moment, I understand, 17/6/2021. It is submitted that by virtue of the
Tribunal order.
order of the tribunal, which is under challenge herein, she has been reverted to the post of assistant engineer.
Assistant Engineer on 5/6/2024.
It is submitted that even in case the contentions of the respondents that the petitioner is not eligible for seniority over the party respondents is completely accepted. There are vacancies available in the post of assistant executive engineer to promote the petitioner and promote the petitioner and to the said post without disturbing the seniority or the promotions granted to the contesting private respondents. It is further submitted by the learned senior counsel for the petitioner that the contesting private respondents have been promoted to the post of executive engineer and that the petitioner's claim for promotion as executive engineer is also liable to be considered in accordance with law. The learned government advocate submits that the petitioner is eligible for promotion to the post of assistant executive engineer with effect from 10/3/2024. It is contended that without disturbing the seniority of the contesting private respondents, the petitioner can be promoted to the post of assistant executive engineer. However, it is submitted that the petitioner is not eligible to be considered for promotion to the post of executive engineer, even if there are vacancies available in the said post. Having considered the contentions advanced, we are of the opinion that in view of the fact that the petitioner is eligible for promotion to the post, in view of the fact that the respondents submit that the petitioner is eligible for promotion to the post of assistant executive engineer with effect from 10/3/2024. The petitioner should be granted the said promotion without prejudice to her contentions in this writ petition and without disturbing the seniority of the private respondents. There will accordingly be an order, direction to the respondents to grant the petitioner promotion to the post of assistant executive engineer with effect from the eligible date without disturbing the seniority of the private respondents provisionally and subject to further orders in this writ petition and without prejudice to her contentions in the writ petition. The further claim of the petitioner that she is eligible and entitled for promotion to the post of executive engineer shall be considered by the competent among the respondents in accordance with law and
If vacancies are there.
if vacancies exist. Ordered. We'll list this after 3 weeks.
But the only question is an order by the government under the Rule 16 would prevail or not. That is the only short question.
Number 2, admission, Prashant Vijay.
Lordship, Section 37 proceedings. My learned friend had taken time to file reply.
Reply has been filed.
Just find the paper books, because there are sufficient readings of the party. Grounds
Very well,
is
Lord.
only legal, not factual. And if it is ready, my lord, may I file it in the office in the course of the day.
Very well, a date
The
may be
date
fixed, Lord.
allows for the matter to be heard once and for all.
And the interim undertaking may be extended.
When shall we have this? 19th?
Yes,
The undertaking may be extended. There's a non-precipitation undertaking.
Yes, yes. The learned counsel for the respondent submits that the paper books are ready and the matter can be heard on a near date. List on 19th for hearing. The parties, the paper books shall be made available by then. The interim, the undertaking, even earlier shall continue in force till the next date of hearing. List
Great.
on 19th.
Great.
3, Basaraj.
My lord, I am appearing for petitioner, my lord. My lord, a short question is ignored, my lord. The petitioner has called for, has issued a notification calling applications to fill up 330 posts of junior engineer civil. My lord, the question is that here the respondent number 1 has done diploma in civil engineering PHE. He has
The
done.
question is with regard to requisite qualification and equality. Equivalence of qualification.
Yes, my lord.
Equivalence. What is this office objection with regard to, is that serious? Can be ignored because the documents produced along with the,
Yes, my lord.
application which I had filed is not.
My lord, as per corrigendum issued by the petitioner, the qualification should be a candidate must have held a diploma in civil engineering general, that is must be holder of a diploma in civil engineering or construction technology and material management granted by the Board of Technical Education, Government of Karnataka. My lord, here is the case wherein admittedly the respondent number 1 has completed diploma in civil engineering PHE. That is not a qualification required for being appointed to the post of junior engineer civil. I will just
a moment. When was the notification?
notification is
37/2020.
37/2020. my lord.
And corrigendum on 7/8/2020.
7/8/2020, my lord.
When was the last date for submission of applications?
Before that only it was issued, my lord.
Hmm.
Corrigendum has been issued on 7/8/2020.
Hmm.
So as per corrigendum, my lord, it is clearly stated that it finds a place on page number 209.
Hmm.
Page number 2, it's in Kannada, my lord. Page number 209. In
Hmm.
second para,
Hmm.
diploma in civil engineering draftsmanship ಮತ್ತು ಡಿಪ್ಲೊಮಾ ಇನ್ ಸಿವಿಲ್ ಇಂಜಿನಿಯರಿಂಗ್ PHE courses. They are having a separate syllabus, and as such, the candidates who have done diploma civil engineering in PHE are not qualified for being appointed to the post of junior engineer, my lord. That's the only point involved here, my lord.
Hmm.
So the honorable KAT has relied upon a decision. Basing on that, it has allowed the petition. It has relied upon a decision, my lord, in a case of B. Tippeswamy versus State of Karnataka. I just draw your lordship's kind attention to page number 180. Page number 180. That is the order. So here, my lord, page number 180, para number 8. I am permitted to read, my lord. Why the honorable KSAT has allowed the petition. In our opinion, the tribunal has misdirected itself in trying to draw a distinction between diploma in mechanical engineering and diploma in mechanical engineering 80. Basically, the recruitment notification of 1/2/2016 did not specify that any diploma other than a diploma in mechanical engineering would not meet the criteria. There cannot be a denial or doubt that the petitioners are holders of diploma in mechanical engineering. The words 80 after the diploma in mechanical engineering will not disentitle the petitioners the basic qualification of a mechanical engineering. The core competence of both the streams of engineering is the mechanics of engine. Moreover, if the recruitment notification does not give, this is very important, my lord. Moreover, if the recruitment notification does not give the details, the same cannot be supplied later. In the opinion of this court, the subsequent distinction sought to be drawn by the appointing authority would amount to changing the rules of the game midstream. If the appointing authority was aware that under the head of mechanical engineering, there were several streams such as GL, MTT, HPT, IT, automobile, and WSM, the notification should have been specific as to the recruitment. The action of the appointing authority is also questionable, since it is an admitted position that several engineers and diploma holders in automotive engineering have been appointed by the department, and they continue to serve the department, which shows that persons like the petitioners have the requisite qualification to carry out the functions as mechanical. My lord, this judgment does not apply to the case of the petitioners. For the reason, my lord, the annexed L clearly unravels the fact that the candidate who has done his diploma in civil engineering PhD is not equivalent. In the case in which the honorable KCT has relied upon, there, my lord, the notification issued therein did not specify that any diploma other than a diploma in mechanical engineering would not meet the criteria. But here is the case where the annexed clearly unravels the fact that the civilian, he must have
We
completed.
understand, we understand. Please tell us what is the provision of the C&R rules?
CL rules provision that my lord, I'm just relying upon the letter issued at Annexure L, my lord.
Forget the letter. Please tell us what is the qualification prescribed in the C&R rules.
Sure. But I will ascertain and make submission, my lord. Short it may kindly be given.
What is the qualification provided in the C&R rules?
Not in the C&R rule.
Letter cannot override the C&R rules. What does the C&R rule say? Nobody seems to have considered that. If the C&R rule says diploma in civil engineering, that is the end of the matter. If the
But
C&R
the
rules
Order of the
actually say-
tribunal may be of some assistance at page 176, my lord.
Yes,
Sixth line from the top, my lord. The
yes.
prescribed qualification was diploma in civil engineering general.
The prescribed
granted by
qualification
the
by the
board.
prescribed qualification by the notification.
By the
That is not the question. Question is simply this: what is the qualification prescribed by the rules? here I find that the selecting authority sometimes goes beyond the rules. It cannot be. Even if there are letters from the appointing authority, the rules cannot be overridden by the selecting authority. What are the provisions of the rules?
Not been produced with the result.
Please look into that and
Yes, yes, ma'am.
tell us
Rules
what.
are not produced, my lord. But,
You cannot go by a notification by itself. Notification has to be in terms of the rules.
And that apart, my lord, the general recruitment rules, rule 2H defines what is an equivalent qualification for the purpose of recruitment.
Equivalence
And it
becomes
says-
relevant when we know what the
Indeed.
prescribed qualifications are.
Yeah.
Without that, the prescription in the notification by itself cannot decide what the qualification should be.
Yes.
Therefore, if the rule says specifically that civil diploma in civil engineering, PHE, then, well, what is stated may be correct. But if the rules say diploma in civil engineering and the PHE is an addition on account of some communication by the appointing authority, it cannot be the ground for a notification.
Yes.
Well, whether the notification was challenged, those would be other questions. Basically, what exactly is the provision of the rule?
Can it be passed over, my lord? I'll get the information. The afternoon. Because if that is the only question, matter need not.
Passover may not be possible. We have
Please, please,
my brother has another bench in the
please.
afternoon.
Any date convenient to your lordships.
Can be next
Early.
week, any day next week. So,
Tuesday or Monday.
14.
14.
My lord, my lord, 14th is inconvenient, my lord. I'll be out of station. Any date after that.
19th,
Obvious, obvious.
20th, man. 19th is
20th,
Monday.
20th.
19th
But
is-
obvious.
19th is no service day.
No, sir.
Preliminary hearing, still number 4. Yatishas,
The respondent, I am permitted to appear on behalf of counsel representing appellant. Lordship, I'm being led by Senior Counsel Mr. Dhyan Chinappa, who is not in station. If it may be had week after next,
Yeah,
because
okay.
he's
Okay.
apparently traveling through next week as well.
Yeah, submission is, my lords, this is listed for preliminary hearing.
May I be permitted to file my objections because it appears to be that several documents that I had placed before the single bench has not been placed before this honorable court. I placed the entire records of the trial court before the single bench.
They have produced whatever documents they have placed, my lords, that.
There was a memo that I had furnished before the single
That, my
bench.
lords, that is not, my lords, of course, not produced along the appeal, my lords, since it was not, my lords.
Shall we have this on 19th?
It may be,
Yes.
can it be had on 20th instead, my lord? My apologies,
Yes, 20th.
obliged.
Let them file it in case if
Yes,
they have any
if
objections.
you're
let them file,
filing
my
it-
lords.
The material is being made available, please do it before then and serve it also in advance.
Yes, your lordship.
So
I will
that-
serve it before I have it filed.
As on that date, there need
Yes.
not be a,
Yes.
Only one short point is, my lords, whether the termination of the workman, but without holding any disciplinary inquiry, but is right or wrong. And my lords, both the courts, labor court as well as the learned single judge are of the opinion that, my lords, termination is without holding any disciplinary inquiry. But however, learned single judge opines that, my lords, you can be compensated. Whether that is right or wrong, my lords, is the issue before my lords.
I've complied with the order. I have already deposited the money before the labor court as well.
10
2030,
lakhs.
10 lakhs is
10
ordered,
lakhs.
my lords.
In addition to that, in fact, I have also paid the workmen an amount of 19 lakhs during the 17B application. So they've been compensated close to 30 lakhs in the period of the writ petition itself.
Now,
19th.
That is the short point involved here.
Alleged.
number 5, Srikanth MP.
Calculation of notes weightage insofar as transfer of teachers are concerned. On the other day, my lords, that is day before, my lords, I made a submission that previous services rendered by us, my lords, in primary school is not being considered because they are interpreting it as, my lords, in the same cadre, which is the high school. And as such, my lords, we are not being considered, one for, my lords, transferred to a different zone, and secondly for transfer itself. As such, my lords,
But I found out, I inquired and I found out the rationale behind that principle is that the direct recruitees will be completely sidelined in the counseling process because if we consider the past service in the feeder cadre before their promotion, they will have a longer length of service and the direct recruitees will not have any opportunities. That is the reason only the service rendered in the current post will be considered for the purpose of transfer.
in
That is
fact,
the
my lord,
rationale behind the rules.
that was the issue raised, my lords,
We
before this court.
understand the rationale, but is it permissible by, under the rules? Because the, like I said, even transfer is governed by
My lords,
enactment and rules here.
They have their own rules, my lord.
My lords, may.
They have their own rules and they have not challenged the
The
rules. also.
submission, my lord, the stand now taken is, my lords, completely contrary, my lords, to the decision of the, my lords, earlier decision. If your lordships kindly come to, my lords, the order of this honorable court, the very same, my lords, contention was raised then. Annexure 8, my lords, page number 149, my lords, the order. And 154, my lords. Those who challenge, my lord, the order of the honorable tribunal. Paragraph 3, my lords.
Yes.
The petitioners who are direct recruiters and working as high school assistant teachers, physical education teachers, are up in arms and agreed by the aforesaid corrigendum dated so and so, filed the application number so and so. Lords, and contended, lords, the very same thing, lords, what is being submitted now. That is, my lords, negative. Upholding, my lords, the amendments which were carried on. And no, my lords, they themselves not come frame the rules.
Just a
Please.
So taking into consideration that the material in support of the case as to how criteria of determining the weighted score based on the service rendered in various zones, including service rendered in previous cadres, is perverse since the objective of the transfer policy is to enable those who have served in zone C or even zone B in their service career to have higher seniority in determining their next place. No infirmity in the improved curriculum and thereby dismiss the application being made.
In fact, affidavit was filed, supported, my lords, para 14. The, my lords, the commissioner, my lords, appears before this honorable court, files an affidavit, my lords, justifying, my lords, the amendments. Now, my lords, backtracking on that, my lords, clearly case of contempt. Para 14, my lords, of the order, the court, my lord, extracts the affidavit. Para 7, my lord, they clearly say, my lords, in the affidavit.
Yes. What does the tribunal find?
Lords, the tribunal, lords, proceeds as if, lords, I am challenging the very rules, lords, which in fact I was seeking the shelter of. If your lordships kindly see, lords, page number 233. Lords, is the order.
Yes.
Paragraph 4, lords, the rules are lord, extracted. Para 6, lords. Milords, completely milords, proceeds on the basis, milords, it is, if I am permitted, milords. It is also pertinent to note that now the applicant want quashing of the amendment of 4A of the rules 2022, and they want to retain the earlier rule 4, weight score of a teacher intact, as present amendment of rule 4A rules 2022 is illegal. No, it was not our contention. We wanted that rule to be operated.
Amendment of rule 4. with the change. That
Milord,
was substituted.
it is extracted, milords, in para 4.
The substitution also said same cadre only for the
3 years, milords.
last item, number of years of
Yes,
service
my lord.
rendered in the present.
This was, milords, considered and upheld, milords, by this court. The tribunal proceeds as if, milords, I am challenging these rules. It is not so. Milords, I am the beneficiary, milords, of this. Milords, we worked in primary schools earlier, milord, came to high school subsequently by promotion. Milords, only, milords, hope is the provision which is now incorporated.
What is the judgment that is relied on?
Milords, milords, the tribunal proceeds, milords,
Nomenclature, cadres, categories, creation, abolition.
milord, the very same judgment, milords, of this honorable court, milords, is considered, milords, wrongly proceeding as if, milords, we are challenging the provision. Para 9, milords. We were not the petitioners.
They are making some observations contemplated by applicants as well as does not create right to seek quashing for way as per amended applicant. What is the interim prayer you seeking?
Milords, what I am instructed, milords, now, milords, I wanted, milords, to participate in the counseling. What I am informed that, milords, the counseling is coming to an end. Milords, my submission would be, milords, the entire thing has to be redone now. Otherwise, milords, this happened, milords, the last year, and this year also we will lose. There are about, milords, 2,000 such, milords, employees who are promoted, milords, from primary school to high school. They'll all lose, milords, the benefit of seeking for transfer.
But I'm told direct recruitees will be completely ousted from the, if they,
That is something that your rules provide. Direct recruits
rules
who
do
have-
not provide for counting the past service.
Rules do. The amended provision does. 4A does. And 4A has been upheld by this court. Now can you? The direct recruits will probably entered service thereafter, that is
Yes,
the recent direct recruits, probably.
my lord, the reason is we worked for several years in Zone C, my lords. They came, my lords, they come after us, my lord, they march over us.
Provision before this court, earlier by filing an affidavit stating that it is not be proper implemented. What is the via media now, how can? This is
Actually,
the situation, how can it be?
Can it be taken up anytime for final disposal, my lord? I will, because today, in fact, the officer also was not there and have not been given the files. That is the difference.
We can post this on 14th,
14th, please.
Please,
because now if, even if they pass an interim order, it may not work to anybody.
That's right.
Please, ma'am.
Because the counseling apparently has gone on. We need a redoing.
Please, ma'am. On 14th,
publish.
grateful.
It's that get instructions and argue the matter by year 15 install it.
Please.
6. Shilpa S. Gogi.
Hearing for petitioner, your lordship. May I request for pass over, your lordship?
So before lunch,
Yes, your lordship.
there is a
Yes, your lordship.
chance of another bench. Yeah.
7, government advocates.
Responded.
My lord, learned AG is appearing in this matter. Can be passed over.
So
He's held up before another bench, my lord. He's appearing through video conference before a bench in Kalburgi.
8, Srikanth MP.
My lords, for the petitioner. Petitioner, my lords, was originally appointed as, my lords, on contract basis. Subsequently, my lords, his services also came to be confirmed, my lords, absorbed. The rules were challenged, my lords, by certain persons who wanted, my lords, appointment, my lords, direct appointment. My lord, the matter went up to, my lords, the Honorable Supreme Court. The Honorable Supreme Court, my lords, at Annexure A4, my lords, was pleased to pass orders, my lords, and also issued, my lords, certain directions. The directions are, my lords, that my lords, the entire list has to be redone. But retaining the appointees, my lords, who were appointed earlier, and if any person is going to go out, they should also be continued, my lords, and be given all the benefits. If your lordships kindly see, my lords, page number 77, my lords. That is, my lords, in respect of directions issued by the Honorable Supreme Court, my lords, at small Roman 6. It says, my lord, they will be entered last, my lords, 2 lines. They will be entered to all service benefits, including seniority and pay fixation, etc., with effect from 21/2004. Subsequently, my lords, I was reconsidered, my lords, continued in service. However, my lord, a case was registered against me, my lords, by my wife, alleging that, my lords, I subjected to her cruelty, my lords, under 498, my lords, under the provisions. An endorsement, my lords, is issued saying that I have suppressed the fact of a criminal case pending against me and has been appointed in the, my lords, by the government, which is not correct. My lord, it is actually a case of continuation of service, my lord, not a case of fresh appointment, as evident from, my lords, the order of the Honorable Apex Court. I've been continued. My lords, if at all there is,
required to make an affidavit to the effect that there is no criminal case pending against you when you were absorbed.
my lord,
My lord,
there
the
was,
order
my lord,
of
I
the
made a
Supreme Court-
statement. There was, my lord, that is also, my lord, ended in settlement. Now there are no cases, my lord, there is a divorce also granted. At the time of absorption, my lords, yes, there was one. My lord, that is now also closed. But proceeding on the basis that I have suppressed the pending criminal case at the time of appointment, my lords, may not be right. It can be a case where, my lords, they can say that there is misconduct, saying that I have not informed or not, my lords, provided information insofar as a pending criminal case. But it is not a case where I suppressed and got the appointment. That is different. They have not initiated any proceedings, my lords, against me. Any disciplinary proceedings are against me, my lords, is not initiated even to this day.
My lord, that is if his initial, if, as my learned friend is saying, if it is a continuation of service, there was no continuations. In fact, his absorption was quashed by the Supreme Court. A fresh appointment was directed to be made.
Just a minute.
The
Satisfactory
direction of the Supreme Court may be noticed now.
My lords, that may not be right.
Will be
76,
absorbed under the provisions of the Karnataka Civil Service absorption of persons appointed on contract basis against backlog vacancies in the category of assistant engineers and junior schools with effect from 21/2004. They'll be entitled to all.
yes, 2004, my lords, was
Just a
initiated.
moment, have now rendered 11.5 years. It would be too harsh for them to vacate the post occupied for them for over a decade. In exercise of our jurisdiction under Article 142, we are satisfied in directing that such of the assistant engineers who have to make way for the regularly selected candidates will be absorbed.
Actually, my lord, it is
When was the
continuing.
case registered against you?
My lords, in fact, my lords, I have produced.
But para 7 is relevant, my lord. Page 245.
In fact, I have produced the order also, my lords, at 174.
The verification report is received on 2/2/2019 regarding a pending case in crime number 118 of 2013, my lord.
Case registered as CC number 1248 of 2013.
My lord, that was closed, my lords, and also divorce is granted. That is, my lords, there is no dispute in, my lords, insofar as that is concerned. Case was registered in 2013. That is, my lords, prior to my, that the order of the Honorable Apex Court.
It is admitted by the respondents that after final decision of the Honorable Supreme Court, a fresh recruitment notification was issued by the government. Applicant has also filed his application for selection. It was selected. Thereafter, as per recruitment procedure, prior to issuance of appointment orders, validation character certificates are sought.
My case that, my lord, it is not a fresh appointment, my lords.
It can't be
Not
a
a
continuous appointment because it was quashed.
There is no
Absorption was
appreciation
quashed.
of that
There
contention.
would be no meaning to the quashing, my lord, otherwise.
There is no appreciation of that contention. Lord, there has to be, my lord, the tribunal, my lord, should consider, my lords, should say that it is not correct. We cannot argue, my lords, when we are subjecting that out, my lords, for judicial review.
What is the status now?
My lord, sir, cases
Yeah.
are closed. Cases are closed. My lord, the criminal cases are closed. Please,
Status of your appointment.
my lords,
What of service?
my lords, I am there, my lords, working. There was an interim order granted by the Honorable Tribunal. My lord, that continued throughout. Now, my lords, they have not, though, my lords, I was in the list of, my lord, candidates being considered for promotion. That is omitted in the last movement, my lords.
Working.
Working, my lords.
But I'm relying on a decision of this honorable court. Even an acquittal will not make a difference if, as on the date of consideration of application.
This issue, whether it was continuation, whether it was the fresh appointment has been, you'll have to probably place readings on that. Consider this.
Since there is a quashing of the absorption order, cannot be said to be continuous.
This is the specific portion, because the Apex Court says they will be entitled to continue. Whether there was actually a further recruitment.
Yes, there was a further recruitment. That is noticed.
Serial?
My lord, it is noticed, my lord. He has been selected to the post of,
There is
my lord, I'm reading para 7.
it says that there is a notification, there is an application.
Please.
Please make available the material.
A fresh recruitment notification was issued by the government and the applicant has also filed his application for selection to the post of assistant engineer on backlog quota. Applicant is also selected as junior engineer.
Yes, make available to you.
Please.
The, notice for correspondence. Scientific instructions and place an objection on record in this inspection. This after 3 weeks.
Can be taken up any early date, my lord, because that is the only 2 weeks.
case the petition is continuing in service, there will be a stay of further proceedings pursuant to the directions.
Nine, K. Prasanna Shetty.
The petitioner, my lord, while working as a senior health assistant, Lord, she was possessed, my lord, illegal wealth, my lord, disproportionate to her known source of income. Lord, DA was, my lord, under 13(2) of the PC Act, FIR was filed and charge sheet was filed.
Sorry?
Under 13(2) of the, my lord, Prevention of Corruption Act, my lord, the charge sheet was filed. However, my lord, on the basis of the complaint, Lokaayukta, my lord, conducted an inquiry. Lord, the articles of charge have been framed. Against that, she filed a application before the KAT, contending that, my lord, Lokaayukta has no power to conduct inquiry, my lord, in the case of DA cases. However, my lord, in the charges are very clear that, my lord, it is only regarding misconduct, my lord. She has purchased some properties, not without taking prior permission from the government. In her name and, sorry. Hence, my lord, use 21(4) and, my lord, 23 of the CCA rules, my lord, it is a misconduct. Similar charges have been framed, my lord, before the Lokaayukta. However, my lord, the KAT, without considering the same, my lord, allowed the application and quashed the articles of charge, my lord. It is impermissible in law. Holding that, my lord, in Kempaya case, my lord, but however, in Kempaya case, my lord, the Honorable High Court judgment, it is very clear that, my lord, when a complaint is filed before the Lokaayukta, inquiry has to be done regarding misconduct. Even it is, my lord, a disproportionate case or it is a fraud case. My lord, on that ground, KAT has allowed the application. It is, my lord, not permissible under law. The notice is not yet ordered. Only on that ground, my lord, KAT allowed the application.
Number one can conduct disciplinary inquiry. So
Please,
yes.
please.
So number one is a state.
Please, please.
She notice to the respondent, to the private respondent, government advocate takes notice for
R1, madam.
R1.
Please. R2 is the private respondent.
Just immediately after.
Please, please.
10, Satish K.
Yes.
It's of suspension, my lord, of a inspector of police on the allegation, my lord, that he have not investigated certain crimes.
Yes.
The tribunal, A2 is a FIR, A2, A3, A1, my lord, A2, A3 are the FIR. All those FIRs state to conduct investigation. Suspension is based on the said delegation, lord, that you have not conducted investigation in 3 crimes, page 91.
Yes. All 3 crimes are state.
State, it is there, lord. They have noted that also in the, my lord, suspension order, page 91.
Yes.
The tribunal, my lord, did not examine anything on merit. On the competency, my lord, ignoring the judgment of the earlier judgment, says, no, the respondent 2 is competent.
Therefore, does not go into the question on merit.
But interim measure, it gives a finding, overruling the earlier judgment. My lord, may kindly see that also. Page 27.
Hence we reject the.
Yes. When on merit, my lord, not a case for suspension.
All 3 investigations stand still.
I have no instructions, my lord, despite sending letters. In fact, one of the officers has been trying since morning and they're not responding. it appears he is, one of them is unwell and he has asked somebody else. And in fact, I think on the last occasion, your lordship had given me a direction to get instructions. There are no instructions.
Government advocates submits that some more time is required to obtain instructions in this matter. In view of the submission made by the learned senior counsel appearing for the petition. That the petition is based on the suspension on the ground that he had not conducted investigation. The two hours, all of which stand stayed by the scope here of the opinion that the petitioner that the public affairs of in this application is liable to be granted. Then accordingly, we are stay of provision of the improved order of suspension. 2022. The disposal of this section is after 2 weeks.
Please.
Hearing on IS, number 11.
For the petition, kindly pass.
Early hearing,
Kindly pass. The PDO transfer matter, my lord. Counseling is, my lord,
counseling
is coming soon, my lord. Kindly pass it. We will ready to, senior counsel is engaging this matter, is held up in.
pass over today if it is possible. It's taken up today. Shall we just say that you will be permitted to participate in the counseling?
This is within the district transfer, my lord. After transfer order implemented, after 3 months, my lord, I am working. Thereafter, my lord, the respondent number 4 brought back to the applicant
Have
place.
to be on the basis of, transfers have to be on the basis of counseling.
No, in this case, my lord, so far as the interim order was granted by this tribunal, insofar as the order of the case is subject outcome of this writ petition.
After the amendment has come into effect.
This is not on the issue, madam, insofar as there is no issue in respect of inter-district transfer.
Yes, pass.
12. Narayan Bhatt.
Appearing for respondent number 21, Your Honor.
My lord, I appear for the petitioner. My lord, the short point is, my lord, the reservation in this higher cadres, my lord, has breached the prescribed limit. My lord, the Honorable Supreme Court, my lord, in the latest judgment clarified that it should not be pertaining to service, it should be pertaining to the cadre. My lord, in the cadre, my lord, this is the cadre of Deputy Director Prosecution. My lord, for scheduled caste, it is 15%. For scheduled tribe, it is 3%. My lord, in both the cases, my lord, it has breached. So reservation was not required to be extended, my lord, in view of Article Section 16, capital A and B. My lord, in the latest judgment, my lord, I have produced that as an annexure also. My lord, may just pass it on, my lord, for easy reference. Please. It is filed, it's an annexure. My lord, it is already produced as annexure A18. My lord, for easy reference, my lord, I am furnishing it. Your lordship may kindly see, my lord, head note B.
Yes.
Constitution of India, Article 16(4), 4A and 4B, and Article 335. Reservation policy for scheduled castes and scheduled tribes. Collection and application of quantifiable data showing inadequacy of representation of SCs and STs in public employment. Basic unit from which such data should be collected and applied, clarified. Collection of quantifiable data regarding inadequacy of representation for SCs and STs held cannot be with reference to the entire service or class bar group, but it should be related to the cadre, grade, category of post concerned.
Now, my lord, your lordship may kindly turn, my lord, I have given details in the petition as well as before the honorable KAT, my lord, in the application. My lord, your lordship may kindly turn to page 34.
Yes.
My lord, table showing, my lord, at the bottom pertaining to public prosecutors.
Yes.
My lord, of a total 148 posts, my lord, 33 posts, my lord, are filled from among the scheduled castes and 8 posts, my lord, from among the scheduled tribe. My lord, this constitutes 22.3% and 5.4%. Then, my lord, senior APPs, my lord, I have shown it below. Here also, my lord, 19.5% and 4.24%. My lord, prior to Pavitra 2 and after Pavitra 2. When Pavitra 1 was rendered, that time itself, my lord, it was above 15% and above 3%. Then, my lord, that new act came in, that was upheld by the Honorable Apex Court in Pavitra 2. Then, my lord, despite 15% and 3% in the cadre of deputy directors and the senior public prosecutors, they did it. Because of that, my lord, it went up to 22% and nearly 5%. That was attacked. My lord, the Honorable KAT holds that I did not challenge the act. My lord, I brought this judgment to their lordship's notice, my lord of the Honorable Bench. My lord, it rejected with no consideration at all.
Does the tribunal say?
Tribunal says I did not attack the order. Your lordship may kindly see the order. It is at one second. My lord, 370, my lord.
375 is where
Pardon-
the orders.
pardon, ma'am.
375 is where the order starts.
Yes, my lord. My lord, in the first paragraph, my lord, what I have contended is has been recorded. My lord, it records in page 376, my lord, the ratio previous to the act, my lord, is recorded at the bottom of para 2, 15.31% and 2.7%. Then, my lord, there is a further discussions. Then, my lord, this judgment, my lord, which I just now submitted to your lordship is referred. My lord, in page 379. Then, my lord, they hold that I did not challenge this act. My lord, your lordship gets it at 385, para 15. The promotion of some of the private respondents to the cadre of deputy director is clearly based on their seniority in the cadre of PPs, wherein they are seniors to the applicant. My lord, this is a factually incorrect observation. Hence, the challenge to the said promotion orders by the applicant is entirely misplaced. The applicant being junior to the private respondent in the cadre of PPs has no right to preferential consideration for promotion, ignoring the seniority of persons in the PP cadre who are placed deputy director shall have to be made with the concurrence of the Chief Justice, so and so, so and so. My lord, I belong to 1994 batch. My lord, the present incumbent, my lord, who is now promoted belongs to 4 years juniors to me, 1998 batch. And my lord, I have made a categorical statement. I have produced the seniority list of Pavitra after Pavitra 1. I have also produced the seniority list of Pavitra 2. In Pavitra 1, my lord, I am senior. Not only Pavitra 1, I am senior, my lord, I belong to a 1994 batch, one batch earlier to, my lord, to this 8th respondent. Despite that, my lord, it rejects my case. This is a short point. This is the case, my lord, on merits also. My lord, may I just point out from the seniority list, my lord, how I am senior?
So there's no equality in the to the cadres, APPC, deputy director being governed by CLR. The government of the applicant is the appointment to the cadres. Will have to be put concurrent.
My lord, para 12, my lord. Para 12, your lordship may kindly see 383.
Yes.
The learned counsel for the applicant has strongly contended that BK Pavitra 2 judgment has been overruled in Jarnail Singh. It appears to us that the Honorable Supreme Court, while considering the case before it in Jarnail Singh, has not followed the norms in BK Pavitra 2 and has directed the judgment to the extent of norms followed in the said case. But we are concerned with the constitutional validity of 2018 Act, which adjudication in BK Pavitra 2 has not been overturned in Jarnail Singh. My lord, this is a factually incorrect observation. Your lordship may kindly see, my lord, the judgment which I just now provided to your lordship. My lord, para 68.
Yes.
My lord, last 3-4 pages, my lord, earlier. The first term of reference for Ratna Prabha committee was to collect data cadre wise. The conclusion of this court in BK Pavitra 2 that expression cadre has no fixed meaning in service jurisprudence is contrary to the judgment of this court, which have been referred to above while answering point number 2. In clear terms, M. Nagaraja held that the unit for collection of quantifiable data is cadre and not services, as has been held in BK Pavitra 2. Article so and so, 16(4)(a) of the Constitution enables the state to make reservation in promotions for SCs and STs, which are not adequately represented in the services of the state. However, the provisions for reservation in matters of promotion is with the reference to class or classes of posts in the services under the state. That groups consist of cadres is a fact which was taken into consideration by this court in BK Pavitra 2. The conclusion that the collection of data on the basis of groups is valid is contrary to the decisions of court in M. Nagaraja and Jarnail Singh. The state should justify reservations in promotion with respect to so and so, so and so. Then, my lord, your lordship may kindly turn to the next page. SS representations, qualifications data, SS representations of SC/STs for the purpose for providing reservation in promotions cadre, which is a part of a group, is the unit and data has to be collected with respect to each cadre. Therefore, we hold that conclusion of the court in BK Pavitra 2 approving the collection of data on the basis of the group and not cadre is contrary to the law laid down by this court in M. Nagaraja and Jarnail Singh. Despite that, my lord, the learned tribunal quotes that, my lord, this is not overruled. My lord, this is a 3-judge bench judgment.
You have a copy of DK Pavitra?
Pardon, my lord.
Pavitra 2 and the 2018 Act.
My lord, act I have produced. Pavitra 2 I did not produce, my lord. If your lordship takes it a little later or Monday, my lord, I'll produce Pavitra 2.
My lord, I pray for, I have received instructions from respondent for 9, 12, 13, 18 and 19 to appear on.
My lord.
May be permitted, I'll undertake to file wakalat on there.
My lord, I am filing it.
No,
Compile.
Your Honors, I am appearing for respondent number 21 and I undertake to file the wakalat.
Yes. Who else? Are all the respondents served?
All respondents are served, my lord.
The act is here?
Yes, my lord. Act I have produced with the main application. My lord, main writ petition I have produced. Your lordship gets the act at page 390, annexure D.
Please. That the respondents, the council file their wakalats.
Please, my lord.
Have it on any date.
At the earliest, my lord, your lordship may have it. My lord, what has happened is, from 1st July, my lord, the new Nyaya Samhita and evidence and it came into force. Just, my lord, on the eve, my lord, the selection procedure changes under the new criminal procedure. My lord, just 30 days earlier, this promotion, my lord, is given effect.
Yes. Everybody else is, all respondents are served.
All respondents are served.
Yes.
9. 13. Prithvish.
Please. But not the names also. Of who appeared online. Yes.
My lord, I have produced the judgments, my lord, Pavitra.
Yes.
It's in this matter. I beg to appeal for the applicant on IA 1 of 2024. This application, let's I am forced to file for this reason. Though the list is purely between the petitioner and the state, I am obliged to file this application for this reason. I have been transferred from Mandya as rainforest officer to Chiknayakanalli, where the petitioner was serving pursuant to antecedent to his suspension. Now I have been relieved from the earlier post and I have taken charge pursuant to the movement order. I have taken charge on 3rd of this month. On 5th, the petitioner moves the Honorable KSAT and questions the order of transfer. And that order is stayed. Let's kindly turn it to
Not
annexure.
the order of transfer, it is the order of suspension.
Yes, no, this is different matter. Before the KSAT, he questions the order of transfer
Yes,
dated
sir.
31/7/2024. Now based on the order of your lordship dated 3/7/24, the Honorable KAT grants an order of stay. Kindly turn to annexure 8, page 44. The relevant is at page 46. Your lordship got annexure 8, page 44.
Chips, can I seek for a
Wait,
pass
one-
or can I seek?
Pass. Wait.
Please.
Great.
B group, seal number 14, Jay Kumar.
You have it done. Speak minute. Senior held up in total.
Which is this matter?
14.1 and 2.
Penalties under challenge. We were working as assistant executive engineer BBMP on the allegation of building violation. We have cleared.
You ready in the matter?
Next week, minute. Next week, minute.
28.
Yes, sir.
15 adjourned, 16. Number
16, my
of
lord,
Vacancy.
16.
Yes.
My lord, I beg to appear for the petitioner. My lord, I request your lordship, my lord, to permit to appear through VC. My lord, I was engaged in. My lord, this had been argued earlier in relation to Article 371J and the notification issued by the state government prescribing the required requirement for an in-service candidate and a direct recruitment. And I have given a convenience copy, my lord, to your lordship. If your lordship kindly have that convenience copy.
Yes.
Because the original paper book is little heavy and all those documents are not necessary. Therefore, I made a convenience copy.
Yes.
My lord, 371J, my lord, as your lordships are aware, which was, my lord, amended by virtue of the amendment to the constitution, which was in the year 2011. Subsequently, state of Karnataka, my lord, issued a notification prescribing, my lord, the requirement to be considered for the reservation to the post in the Hyderabad, Karnataka region. Now, your lordship may now kindly come to page 12. Your lordship got it, my lord?
Yes.
Page 12 is the starting of the notification issued.
Yes.
My lord, at Page 14.
Yes,
Dom is a local person.
yes,
Lord, a candidate for direct recruitment
yes.
or promotion
Hmm.
to any post shall be regarded as a local person in relation to local area.
Correct.
Now, a candidate for direct recruitment, the prescription is this. That is, if he is born in the local area or either of his parents was born in that region before 1/1/2013, or either of his parents ordinarily lived in the local area for more than 10 years. In case where minimum educational qualification has been prescribed for the recruitment to the minimum education, this is for direct recruitment. For the purposes of promotion, my lord, for existing employees, sub-rule E. Your lordship got it, my lord?
Yes.
For existing employees for whom these rules apply, entry in the service register. Therefore, two things are contemplated. For a direct recruitment, my lord, he should obtain eligibility certificate. For the purposes of the in-service candidate, my lord, his service register disclosed before 1/1/2013, he hailed from those districts. Now, thereafter, my lord, your Lakshmi kindly now come to page 23. This is the subsequent notification prescribing the eligibility certificate for whom this shall apply.
Yes.
My lord, in this, at page 30, at page 30, my lord.
Yes.
Categories of certificates. Any person claiming reservation as a local person in direct recruitment, please note that, my lord, shall obtain following certificates issued by the competent authority.
Yes.
A direct recruitment, my lord, should obtain eligibility certificate. My lord, this eligibility certificate, production of this eligibility certificate by an in-service candidate is not contemplated, my lord, under the rule at all. In this case, in our case, what happened? My lord, my promotion, my lord, got withheld for the reason that the persons, my lord, who are in-service candidates, my lord, obtained eligibility certificate from couple of districts. And based on that eligibility certificate, their seniority, my lord, was being fixed. With the moment I came to know that, I objected, my lord, and I gave a representation.
Yes.
And my seniority, my lord, was directed to be refixed. Even then, the persons who had obtained eligibility certificate or claiming promotion seniority on the basis of the eligibility certificate were being placed above me, notwithstanding the direction. Under these circumstances, I filed a writ petition. My lord, writ petition, my lord, was disposed of, directing me to go to the tribunal. Before the tribunal, my lord, it has been dismissed on the ground of delay.
What does the tribunal say? Please take us to the.
Yes, my lord. The tribunal order is in the main paper book. Is that in the main paper book, volume number 2.
Yes.
Start from page 385.
Yes.
My lord, the reasoning starts from page 395.
Yes.
In the light of oral arguments, we have examined the entire record. Applicant has sought for relief in the following grounds. The respondents are ignoring the applicant seniority, have accorded promotion to 6 to 14 illegally. The inaction on the part of respondent number 2 and 3, not considering the applicants, is illegal, perverse, so on and so forth. We have taken both points together for our discussion at page 397. For our discussion, as both points are on perusal of the length grounds mentioned in para 36, the applicant himself is not definite about his grounds, and he himself is in ambiguity in seeking the perfect relief. It is settled law that if the relief on the grounds mentioned in the application are all inconsistent and not understandable, there is no nexus. My lord, I am unable to understand, my lord, how the uncertainty of pleadings. Annexure A1 to A4, promotion of the respondent 6 to 14 are 7/9/2016, 23/1/2017, 21/3/2017, and 17/7/2018, respectively. On reading of all, it shows that respondents were promoted on different dates as Deputy Superintendent of Police and posted to different places as stated above. It is pertinent to note that first promotion has been accorded on 7/9/2016, in which nearly 12 officers are promoted. For the reasons based on, he has not at all challenged the promotion. But I am not challenging the promotion granted to the officers who are eligible, my lord. It is the issue in relation to the persons who come under the Hyderabad Karnataka reserve category.
Even their promotions you did not challenge appears to be the finding.
No. Their promotions are, I am not challenging their promotion for the reason that they do not claim the promotion under the Hyderabad Karnataka category. My lord, may I clarify, my lord? The promotions of 6 to 14 are challenged.
When were 6 to 14 promoted?
My lord, 6 to 8 were promoted even before, my lord, the amendment came into force. I am not agreed by that. My grievance is, please come to the convenience copy, my lord. My grievance is 2017 preparation of seniority list. It is at page 130 to 126, my lord. One 26. 125, my lord. The English translation of this is at 130. 27/11/2017 notification.
Yes.
My lord, in this, please come to 126.
Yes.
This is preparation of seniority list. I am not challenging the promotions which had been accorded to them earlier in the regular this thing. 126, my lord.
Yes.
My lord, I am placed at serial number 40.
Yes.
Now, Shankar M. Raji is placed at, my lord, serial number 5.
Correct.
Sangappa Siddappa Hullur is placed at serial number 6.
Yes, they are all actual date of promotions were much earlier than you.
No, that is
promoted in
that promotion I am not challenging. This is after, my lord, the reservation came into force. My lord, they are in the process of getting their seniority list prepared, waiting for the next promotion on the basis of eligibility certificate.
What exactly was your challenge, Council?
What exactly our challenge was that
What was your challenge before the tribunal? Please tell us what the prayer was.
prayer, my lord, is found that.
Prayer before the tribunal.
Yes, my lord. Well, it starts from 165. Application number. Please come to 176, my lord.
Volume 2.
Volume 2.
Yes.
My lord, I have given the chart. And my therefore
Please
being
tell us
amused,
what was your prayer before the tribunal?
my prayer is at page 195.
Yes.
Issue a writ of mandamus directing to accord promotion to the applicant to the next higher cadre, Deputy Superintendent of Police, from the date of applicant is eligible during 2030. The person,
It must be on the basis of the settled seniority in the post of Inspector of Police that the issue has to be considered.
so far as Inspector of Police is concerned, these persons respondent 6 to 14.
Which is the final seniority list?
Final seniority list, my lord, is 2017. There, they are according promotion.
Have you challenged the set list?
The set list, my lord, is
the seniority list of 2017.
Yes, my lord.
Where?
Page 196.
Yes.
Annexure P22, 2017.
Your application is of the year 2022.
Correct.
How can
That
you
is
challenge
because
the 2017 list?
That is because in 2018 I filed a writ petition. The writ petition, my lord, writ court directed me to go to the tribunal. This
When
was
did the
in, this
when
was in,
did the report, when
my
did
lord,
the report require you to go to the tribunal?
my lord.
When was the writ petition closed?
The writ petition was closed in 2019, at the time when the COVID came in between. Therefore, my lord, there was some this thing in filing an application. This has not been considered by the tribunal at all. The ultimate question is, my lord, is this, that whether for the purposes of promotion and for the purposes of preparing the seniority list to be prepared to come under Hyderabad, Karnataka region, my lord, whether an eligibility certificate can be used for the purposes of in-service candidate. That's the question.
When was it used?
That was in the seniority list.
At the time of their promotions to the post of Inspector of Police.
No, Inspector of Police, nobody had been used because all these appointments are in 2000, 2001.
Okay. Therefore, it is for
It is
promotion to the higher cadres. That
higher cadre preparation of seniority list. Supposing
it's not for seniority list that an eligibility certificate is used. It is for promotion.
Correct, but seniority list is
When-
based on
when was the promotion made?
promotion, my lord, took place, my lord, in 2017 and 18, based on the seniority list. Therefore, I challenged it.
Just a moment. Yes.
When approaching the tribunal, there was a delay, my lord. It said that after a lapse of 18 years, page 402. it states that-
Yes. How can that be correct? 71 comes into effect only in 2013. The orders are only of the year 2013 and 14.
Page 402. Right. After multiplying,
Yes.
it says that mere giving of representation cannot create a fresh cause of action. In page 400, the judgments number. Then in page 402, reading the above judgment, the Honorable Apex Court said that the High Court is not justified in rejecting the preliminary objection based on laches. The applicant therein had challenged the seniority other than
Because therein,
that case.
that case.
My lord,
Cannot be questioned by the concerned person as it is totally part of the education.
Hmm.
In present case, the private respondents were promoted in the year 2016 itself, and the applicant had not at all challenged the same well in time.
That
but
is the
not
finding.
only
That is the finding.
approached the high guest
2016 is the promotion.
stand correct.
2016.
Even when he approached the High Court, it was already barred by him.
The approach to the High Court was in 2018.
2019 is what is stated.
18, my lord.
Which is the writ petition?
My lord, writ petition number is 11537 of 2018.
In case also it is barred by him.
My lord, this writ petition, my lord, was disposed of directing me to approach the tribunal.
Where is that?
My lord, that order passed by this honorable court in writ petition is at page 144 to 152, my lord, the order passed, my lord, in the writ petition. I go for a moment, my lord. I'll. One minute. No. Yeah. My lord,
The orders are not under challenge. Council, we hear this on another day. Please be ready with the material. The government orders are not under challenge. The orders saying that for the purpose of promotion in service, the entry is required. That is not under challenge. The promotion orders are also not under challenge. The fixation of seniority, 2017 is the final seniority list. The 2017 list that is the final seniority. Yes, we'll hear it on some other day.
Lord, any date, my lord, may be fixed, my lord.
Yes, 27.
Oblate,
27.
27.
17, Inayak B. Vishnu Bhatt.
Therefore, the petitioner. Lord, the selection is for the post of, my lord, assistant professor in Kaya Chikitsa in Ayush department. Lord, Annexure A1, page 75 is the notification.
My lord, facts are not in dispute, my lord. In this case, only legal issue. Annexure A1, page 75 is the notification. In that, my lord, page 76, serial number 21,
Yes.
my lord, Kaya Chikitsa. One post, my lord, in the non-Hyderabad Karnataka and one post in Hyderabad Karnataka.
Yes.
My lord, the applicant, the petitioner and the applicant both, my lord, they filed application under the non-Hyderabad Karnataka category. My lord, in the said notification, page 81, my lord, clause 6.2.
Yes.
My lord, it says, my lord, after becoming eligible in the Kannada language, the candidates will be called in 1:3 ratio.
Yes.
Then, my lord, the eligibility is also not in dispute, my lord. Both are eligible. That is not in dispute. Eligibility is at page my lord, 110. Serial number 17. 110, my lord, serial number 17. Not that. 115, your lordship. That is for associate professor. Assistant professor is
Professor is
115, I'm sorry.
47 and
48.
Kaya Chikitsa must
Kaya
possess
Chikitsa.
bachelor degree in Ayurveda, postgraduate degree in Kaya Chikitsa, awarded by university, established by law, etc. What is column 7?
That is the serial code which gave in the notification. That is in, so that they have steps. That is not.
Yes.
Then, my lord, the KPSC, my lord, issued the selecting authority, issued, my lord, shortlisted candidates, list of shortlisted candidates, that is at annexure A3. Page 130, my lord.
Yes.
3 persons are there. One Tejaswini HJ, Kavya Shri, and then, my lord, Annapurna, who is the petitioner here. Lord, 3 persons were shortlisted and called for interview. My lord, at the time of interview, my lord, the selecting authority found that, my lord, the first 2 candidates, they were from some other stream, not from Kaya Chikitsa stream. So they didn't interview them. Please. They didn't interview them. They, without interviewing them, my lord, they were rejected. I was the only candidate who left. I was interviewed and, my lord, marks were awarded. And, my lord, I was then provisional list was issued. My lord, before that, my lord, the applicant, who is the respondent number, my lord, 4 herein, appears to have filed objections to the short list, my lord, annexure A4.
Yes.
Annexure A5 is the one, page 134.
Yes.
Is the provisional selection list, wherein, my lord, my name is shown as a selected candidate. Marks is also revealed. That is, my marks, total marks is 214.
Yes.
This is relevant, my lord, because the marks are really not revealed before the interview.
Yes.
Then, my lord, annexure A6, etc., my lord, the respondent number 4, applicant before the tribunal, my lord, filed objections. Annexure A7, page 144 is the final selection list. Thereafter, my lord, the appointment order has been issued in my favor. I have been selected. Then, my lord, the application is filed by 4th respondent before the tribunal, challenging the final selection list and provisional selection and endorsement. My lord. Final selection list and endorsement at annexure A9, page 149, is the endorsement issued to respondent number 4.
Yes.
My lord, it's in Kannada. It says, my lord, as per the rules, they have called for 1:3 candidates. And your objections are considered. We have done the appointment in terms of the so and so rule, and the objection is rejected. Then, my lord, application is at my lord, page 50, and my lord, the tribunal set aside the appointment, my appointment, and my lord, to redo the process from the stage of shortlisting of the candidates. My lord, Annexure A, page 17 is the order passed by the learned tribunal. My lord, before taking your lordship, my lord, to the reasoning, my lord, in page 23, my lord, ink page 23, para 7. My lord, the last 4 lines, my lord, viewed in this manner, the interview list for the post of the residual parent cadre required to consist of 3 candidates. That the 3 candidates ought to be the top 3 meritorious candidates on the basis of the result of the written examination is not in any dispute among the parties. Then, my lord, in the contention of the applicant is that the 3 candidates must be those who are eligible for selection. That is, the 3 candidates must fulfill the eligibility conditions. 2 at the time of the interview personality test. The learned KPSC council differs, and the learned council for the 4th respondent disagrees that it should be so. This is where the difference unfolds. The learned KPSC council states that the list shall comprise of first 3 persons in the order of merit without reference to their eligibility, while the applicant's council contends that the interview list shall comprise of persons who fulfill the eligibility conditions. The learned council for the 4th respondent contends that the eligibility for shortlisting for interview personality test is merit in competitive examination. The learned KPSC council contends that the C&R rules does not contemplate that interview list shall comprise of eligible persons only, and that it shall comprise of those who were meritorious in the written competitive examination.
Yes. It's a little strange, the stand of the PSC. At what stage will the eligibility be considered?
Will be verified before permitting them to enter the student hall, before conducting the personality test.
Correct.
We will prepare the list of eligibility of candidates in the ratio of 1:3 in the present case, as per the merit. There is no dispute.
Correct.
There is no dispute. The thing is, out of 3, 2 become ineligible.
Because they did not have the prescribed qualification.
We came to know only at that point of time.
Just a moment. Prescription of the qualification. Is it not available for you to assess even at the time of submission of the applications? Because what do they claim? They claim that they are qualified, they have the postgraduate qualification in the concerned discipline. That is, according to you also, that is the qualification.
For that, your lordship get it answer at page 83 in the notification. That will clear stage. Page 83.
Yes.
Point number 10, your lordship.
Yes.
It's in Kannada. I will try.
Yes.
Shaikshanika Vidyarthi means requisite educational qualification.
Yes.
Vayomati means age.
ಶೈಕ್ಷಣಿಕ ವಿದ್ಯಾರ್ಥಿ ಮೀನ್ಸ್ ರಿಕ್ವಿಸಿಟ್ ಕ್ವಾಲಿಫಿಕೇಶನ್. ಅರ್ಜಿಯು ಭರ್ತಿ ಮಾಡಲು ನಿಗದಿತ ಕೊನೆಯ ದಿನಾಂಕದಂದು ಅನುಸೂಚಿಯಲ್ಲಿ ಆಯಾ ಹುದ್ದೆಗಳು ಮುಂದೆ ಸೂಚಿತ ವಿದ್ಯಾರ್ಹತೆ ಅಭ್ಯರ್ಥಿ ಹೊಂದಿರಬೇಕು. ನಿಗದಿಪಡಿಸುವ ವಿದ್ಯಾರ್ಹತೆಯನ್ನು ಹೊಂದದೆ ಹೆಚ್ಚಿನ ವಿದ್ಯಾರ್ಥಿ ಹೊಂದಿದ್ದರೂ ಸಹ ಪರಿಗಣಿಸುವುದು. ದಟ್ ಮೀನ್ಸ್ as notified in the schedule, the requisite qualification has to be there as on the date of the person who doesn't hold the qualification as on date and who doesn't fulfill even after that, he is ineligible. So this is a mandatory one. It is followed by the requisite, because your lordship, the qualification for any post is what is required under C&R. Competitive examination is only a procedure which is contemplated under 2006 rules. But if a person merely that I hold another specialization
And if I compete with the competent written examination holds the marks, that doesn't take away a person. Otherwise, the very purpose of interview will be diluted if the persons who are not there in the selection process. But minimum qualification is under the notification itself, not that. But perhaps the answer of the tribunal before the tribunal by the KPSC is that no, since there was enormous candidates who applied for different disciplines, we have allowed them to take the examination. Only we scrutinize at the time of the interview.
Should there not be 3 eligible candidates for the interview?
That's the basic.
Should there not be 3 eligible candidates for the interview? Is that not the intention?
And this fact, in the 1:3 list, all the 3 were eligible. Only at the time of sending them to the interview board, you will verify the documents. At that point of time, we came to know that.
Correct. When you find that 2 are not eligible, then what would be the?
There is no provision which empowers me to again prepare the 1:3 list. That is the problem.
The notification.
Provision which empowers the KPSC to prepare the 1:3 the second time.
Yes. What does the tribunal say?
Not
The finding is coming at para 7-14. That's
not
very
the.
Let me learn it.
Yes, will you continue,
Not
please?
Para 14.
Stop that. Middle of para.
Yes.
Para 14, my lord. Thus we are of the considered view that the KPSC was correct till the stage of verification of credentials of the candidates who have been invited to the personality test. But once KPSC found that the candidates shortlisted for interview are not in the ratio of 1:3, it was necessary for KPSC to revise the shortlist for interview personality test to comprise of the necessary numbers of candidates to comprise 1:3 ratio. In these circumstances, the process of KPSC has failed from the stage of conduct of personality test, and the process needs to be redone to determine the selected candidate from that stage. The select list of so-and-so A7 by which the 4th respondent was selected and the impugned endorsement by the KPSC at annexure A9 being unsustainable in law and deserving to be set aside to facilitate the completion of the selection process in accordance with the rules. This is the reasoning of the
The reasoning starts from page 8, para 8. Chip, that is the conclusion part in my learner. The reasoning starts at para 8.
No, we understand the reasoning. Paragraph 11 says we agree with the learned counsel to the applicant that when KPSC realized that the interview shortlist did not comprise of the requisite number of eligible persons in the ratio of 1:3, the KPSC was obliged to call other candidates in the order of merit, examine their eligibility and formulate the shortlist for interview accordingly. Yes, you are the applicant. The applicant was?
My lord, applicant was at the, my lord, I got 174 marks.
I'm
He got
173.
173 marks. My lord, she was the,
The lordship will get it 161 and 162, para number 8 and 9 in my reply statement. You have taken mainly 2 contentions, my lord. No statute which empowers me to prepare the 1:3 list for the second time.
my lord, may I produce
And
the
second is
notification?
the respondent number 4 does not claim that, I am more meritorious. The KPC has selected the person who is less meritorious than me. No, we have selected the person who is more meritorious than the respondent number 4.
Question is simply this.
Yes,
Should there be 3 persons? If the
1:3, 3 million.
1:3, should there be just 3 persons?
Yes, ma'am.
Or 3 eligible persons?
3 eligible persons. 1:3, 3 persons.
If you say it is, if you admit it is 3 eligible persons, 3 has to be.
That is the reason, lordship, they have redone so.
One minute, please. You will prepare the list based on the information and the merit furnished by the candidates. Afterwards, we will look into it, whether they are eligible or not. Before sending them to the
That exactly is the question.
Yes, my lord. Now, the hurdle for the KPSC is no statute which empowers the KPSC to prepare the 1:3 list for the second time. Since these 2 are not eligible, I cannot go on adding and preparing the list, my lord. So what the KPSC did is,
My lord, the rules, relevant rules, same.
2006 rules. Now it has that over 2000 6 rules have been wiped off. 6 rules, it is not that rules that I have got,
There are other rules.
because that 2006 competitive rules has been amended not one time. Till today it is amending to till 2021.
2021 rules are also.
Yes.
It's an admitted fact, my lord.
My lord, para, my lord, para 9, my lord, page 8, para 9. Interview for group A, B post only, my lord. My lord, in that, my lord, page 9, candidates as equal to 3 times of the number of vacancies notified shall be called for interview. The rule simply says, my lord, 3 times number of candidates.
Examination of the qualified examination shall not be published on the. They shall be kept strictly confidential. Maximum marks for interview shall be 5% of total marks. The method of selection.
Lord, KPSC.
Authority shall call the candidates in the ratio of 3 candidates for 1 vacancy. In the ascending order of their register numbers, ensuring that reservations for candidates.
Lord, in the said rule, my lord, the marks secured by the candidates in the written examination or qualifying examination shall not be published or made known to the members of the members conducting interview. They shall be kept strictly confidential. The maximum that is relevant, my lord. Because, my lord, when my selection list was published, my marks was revealed, my lord.
The selection authority shall scrutinize the application along with the enclosures received and may call the candidates for the purpose of scrutiny only at the time of interview if necessary. Where interview is not prescribed, scrutiny of application shall be done only on the basis of application and enclosures received. Selection authority shall be present.
The selection authority shall scrutinize the applications along with the enclosure. Incident may call the candidates for the purpose of interview only at the time of interview if necessary, where the interview is not prescribed. Time the commission come across this type of.
Because of the technical problem that so far medical officers are specialization requires only if this has been accepted, there is no competence respondable to it. And automatically, even if she is accused 0, because 12.5% of marks of few marks. That is what the tribunal has considered.
Yes.
No, my lord, there is a rule. And the KPSC has plainly, my lord, they have referred to the rule and they have done the appointment in accordance with those rules. My lord, I have not done any mistake. There is no mistake on my part. My lord, I participated in the interview. I secured certain marks, my lord, I was held eligible. Therefore, my lord, the appointment process, which is conducted as per the rules, my lord, could not have been found fault with by the learned tribunal, my lord. That is my first argument. My lord, I faced the interview, my lord, and my marks are revealed. One of the provision which says, my lord, the marks are not revealed to the members of the interview. That is kept secret, my lord, till appointment is over. But in the final selection list, my lord, my marks was revealed. It was known to everybody, my lord, even for the respondent number 4 also. Then, my lord, the second argument is, my lord, the order passed by the KPSC to the extent of, my lord, redoing the whole process, that prejudices me, my lord, because I faced the interview. My lord, if at all, my lord, the tribunal found fault with the selection, it could have directed the KPSC to interview two other persons. And my lord, it should not have made me to face the interview again, my lord. In the second interview, now, my lord, I filed the writ petition immediately. There was no interim order. The KPSC went ahead with the next process. And my lord, I even filed a stay, my lord, of the interview. My lord, my application was pending. And I, my lord, participated in the interview, my lord, under protest. Now, my lord, after the interview, my lord, I have been, my lord, not selected by 1 marks. And the fourth respondent is selected. In the interview, my lord, the second interview, I have been.
That we don't know. He's submitting 1 mark. The written examination marks is 174.
But
he is here, like,
my lord, what?
clarify this. 174 which the petitioner has secured. I have secured 173. It is not the written examination marks only clarified for the purpose of, it is only for the shortlisting for the interview. They have shortlisted, they found that the two other persons are not belongs to the stream of specialization. Then they itself have made an objection. When they have notified, immediately I filed an objection.
No, that is not issue. No,
It
no,
is
my
the
lord.
issue for me because I am the person who was claiming for that.
My lord.
Having filed objection, the KPSC refused to consider the same. Then they followed with the interview process. They conducted interview only for one candidate. That is the petitioner here. For that, they have published the provisional list. Even then also I filed an objection. Then they finalized the final list. Then for that, I have approached the KPSC by filing a detailed objection. For that, they have issued an endorsement stating that as per 2006 rules, there is no procedure for doing the review. But the basic issue is whether the notification prescribes the basic qualification. It's a written competitive examination. I am eligible to write the competitive examination provided if I fulfill the qualification of that.
No, there is no
It
dispute.
cannot-
Is the competitive examination common to all the specializations? No.
It differs because it's a specialized subject. Specialized subject.
Is a separate
Complete-
examination?
It's a specialized because medical officers comprise of various specialty.
My lord, one submission, my lord, these facts are not in dispute, my lord.
Correct.
Now, your lordship may kindly see the final selection list at page 144, annexure A7 144.
Yes.
My lord, my total marks, after the interview is 214. Therefore, I was selected in that, my lord, the first selection process. Now, my lord, along with the amendment application, my lord, I have filed the notification, the new notification by which the fourth respondent is selected. She has got total number of 213 marks. In the first, if your lordship consider my first interview and total marks, it is still above the fourth respondent.
If at all, the question is whether the second interview is liable to be conducted or not at all. Whether your first interview was proper.
Please.
If your first interview was proper and you were eligible for appointment, then the second interview question does not arise at all.
Please.
As a matter of fact, what is being stated is correct. And there has to be an interview with 3 eligible persons. It can only be that interview. The earlier interview, and the
will
marks
be,
you secured in the exam, in
Lord,
the earlier interview.
Lord, if interview,
Be carried forward now.
Lord, it is
Just
not,
one interview by one board. Cannot be one interview for you. and
Cannot be a
another
common
interview
for both the
somebody else.
boards.
Cannot
The
be.
competition has to be among the
And
person's
it must be-
eligibility.
And it must be, therefore that question we are examining here. What is the stage have you been appointed?
I've been appointed.
no, I have been,
But
my lord,
When
got
London
my,
has filed a writ petition, this matter has been heard. The previous bench has directed, since a lone person cannot be appointed without competitive, let the process start and you participate. There was no such.
Order
Yes,
to
that
that
is an
effect.
order. That is an order. The Lordship has considered, even rejected their stay application for my appointment also. That is because I raised a specific contention in view of subsequent event. It cannot be adjudicated here. It has to only be for the tribunal. The Lordship, we will allow the application for amendment since it is a continuous process. That is the reason I said without restriction to my appointment. The Lordship kindly see the order sheet for this since from the date of. He has not even protested. There is no
Before,
such thing.
before my learned friend,
Ratio comprising candidates in the order of merit who are eligible to be selected today, having fulfilled the eligibility criteria, which shall include the fourth respondent and proceed to conduct the personality test afresh and determine the selectors both. Term classification replacement subject to vacancies records for the selection personality test is already conducted. Not that there is. Yes, yes.
Because I am not the only person. Along with me, there is other person who is eligible. She is also participated in interview. It is not only the petitioner or the respondent hearing. 1:3 as per the eligibility.
We permit the amendment of the petition subject to the objections raised. The selection and appointment carried out pursuant to the directions of the tribunal. So far as the contested respondent is concerned, shall be subject to.
result of 3 days. My lord, I left my job. So I was working somewhere else and I left my job. My lord, I was appointed. I worked for nearly 1.5 years. My lord, before the tribunal passed the order, my lord, I had joined the duty, but the tribunal refuses to consider the question of equity. My lord, considers it wide ab initio, but it cannot be wide ab initio because, my lord, there was no fault on my part or any misrepresentation on my part. This was the situation. My lord, there are vacancies. There are vacancies. There are vacancies. My lord, in similar circumstances, my lord, this honorable court, my lord, granted, my lord, directed the government to do such exercise. My lord, this is my position. I worked there, my lord. I left my job. I was working in some other medical college.
To quantify my learned friend contention, logic, 2006 competitive examination, normally it is for those who have basic degree, for example, KS and all. For specialized post, it should be as a qualification, otherwise.
But my lord,
Is the instructions
and my lord,
was the examination a common examination? If not, for participating in the examination also, should they not complete the eligibility criteria?
Even if it is common, because when you apply for specific post, the notification clause 10 is mandatory. My learned friend is reading 9. The interview parts only comes after
my lord,
the
even
Not the application show what the qualification is.
yes, it is mandatory.
Would not the application show? If the application shows a postgraduate degree in some other discipline, why are they being?
my lord, in fact, my lord, that didn't challenge your, my lord, rejection.
We understand that. We understand.
You cannot stop them from filing this type of application. Because thousands and lakhs will there, they will file and it's not possible for
The end result will be what we are facing today, if that has not been done. This is the first time it has happened. Normally, competitive examination is only for the KH, not for this.
And my lord, because of the order that to redo the selection process from that stage, my lord, I am prejudiced. My lord, why I am saying that, my lord, my first interview marks has to be considered, and my lord, the second interview mark should not be considered. There is a reason. My lord, there is a strict prohibition, my lord, for revealing the mark to the board. Second time, I am prejudiced, my lord. I have made certain, my lord, statements in my amendment applications also. There was no proper awarding of the mark, my lord. Because, my lord, my marks was revealed and therefore, my lord, I am put to prejudice.
My learned friend is making an allegation. I read
I-
that. Then he had to incorporate the members of the committee.
Yes, please tell us whether qualification. Vacancies.
There are vacancies.
There are vacancies. He's admitted there.
As to how the issue can be resolved. It appears it is not the fault of the candidate. It appears to be, even if what is stated is all correct, then the calling for it, whether if the others should have been called, if as on that date, it is found that there's only one eligible candidate, if the others have been called immediately, probably the situation would have been different.
Because I intimated much before. When they shortlisted, then only I filed a. The process of interview has not commenced at all, but they have refused.
Yes, government advocate as well as learned counsel appearing for the PSC. Shall get further instructions in the matter. As to the conduct of the competitive examination as also whether there are vacancies available to accommodate the petition here. This after 3 weeks.
Please. Great. Lord, your lord-
Vacancies are there, your lordship.
your lordship may have it after 2 weeks, my lord.
Can be provided if the government comes up. Because this is
My lord,
mistake
vacancies-
committed either of the parties, not either of the parties, it's purely by the
My
authority.
lord, vacancies are available, my lord. I have ascertained, my lord, vacancies are available. Your lordship may have it after 2 weeks, my lord, any 2 weeks, my lord.
That takes about
Oh, please.
Please. Great.
18. AGA government. Shiva Reddy. Your petition.
Yes.
19.
Asked a question. Against the petitioner. And therefore, the government advocate was directed to secure information whether what is the law and the point and what is that they are doing with respect to these penalties, my lord, because it is only a deferring of the penalty order. Deferring the increment for 2 years. That was the penalty, minor penalty was imposed as against the petitioner, my lord. In the meantime, my lord, his juniors were promoted and subsequently, my lord, after the period of this punishment, that is after the deferring is over, even the petitioner have been promoted as HC. Now, my lord, the next post is from PC to HC, HC to ASI. Now, my lord, his batchmates are being promoted now. I mean, in the year 2022, they are promoted. But at that point of time, the petitioner was not considered. Therefore, he made a representation before the authorities to consider him for the post of promotion. It was only a minor penalty of deferring the increment, not withholding the promotion or anything else. So therefore,
The increment means it is a minor penalty of equivalent to withholding of increment without cumulative effect.
deferring, my lord. So with us, it was not withhold.
Deferring is withholding without cumulative effect. What else is deferring?
So therefore,
Deferring means for that period of 2 years, you will not be eligible for increments.
increment.
After 2 years, those increments will be
Given
made
to-
available. This withholding without cumulative effect.
So now, my lord, in the meantime, what I'm seeking is, my lord, promotion when my juniors were promoted. That's what I was asking. Because,
You made a representation. to that
yes,
effect.
my lord, I made a representation. my lord. That representation, your lordship may kindly see. Annexure A, page number 45. Kannada, English version is in page number 52. May I read, my lord?
Just a minute.
Last time I relied on a judgment of the Honorable Apex Court.
Your representation has been rejected.
Yes, my lord, it has been rejected, challenging that, my lord, annexure A4, my lord, page number 56 is the, this thing, my lord, that English version.
Yes.
Page number 57, my lord, as per the final order of the department, my lord, second paragraph.
Yes.
As per the final order of the departmental inquiry, you were given one annual increment deferred for 2 years without affecting the next annual increment. And the period of suspension from so and so was considered as suspension. After the expiry of DA order, you were promoted from PC so and so to HC so and so on 26/6/2019. Since the DA order period has expired and considering that your batchmates of the year to have been promoted from HC to ASI, since to your request for re-inclusion in the seniority list for the promotion from HC to ASI is hereby rejected.
The period has expired and considering that your batchmates of the year 2001 have been promoted from HC to ASI since 2020. The request for re-inclusion in the seniority list for promotion from HC to ASI is here. What do the rules say?
My lord, there is a circular, my lord.
Yes.
It's actually based on the judgment of the Honorable Supreme Court in Janaki Raman case.
Yes.
Not only says that, my lord, in this case, in fact, there was a DPC pending when the juniors were promoted.
Yes.
And the RPPP rules, Regulation of Promotion, Pay and Pension Rules provides the only circumstances in which a retrospective promotion can be given. It is only in the case of exoneration and two more conditions are mentioned, which do not apply to his case. My lord, the circular is produced as an annexure, my lord, at annexure R1, along with our statement of objections
Yes.
at page 11.
Yes.
It's a circular at page 11, my lord.
Yes.
Your lordships may kindly notice page 12, where the extract of
Statement of objections ಕೊಡ್ತಿದ್ದಾರೆ. Not solved upon.
ಕೊಟ್ಟಾಗಿದೆ ಸರ್. ಆಲ್ರೆಡಿ ಗಿವನ್.
ಇಲ್ಲ ಆಗಿಲ್ಲ.
ಕೊಟ್ಟಾಗಿದೆ ಅಂತ ಸರ್. ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಕೊಟ್ಟಿದೆ ಅಂತ ಇದೆ.
Notification ಕೊಡಿ.
There is no objection.
Yes. Statement
But
of objections
an
filed on
employee has
14.
no right to promotion. He
Yes.
has only a right to be considered for promotion. The promotion to a post and more so to a selection post depends on several circumstances. To qualify for promotion, the least that is expected of an employee is to have an unblemished record. That is the minimum expected to ensure a clean and efficient administration and to protect the public interest. An employee found guilty of a misconduct cannot be placed on par with the other employees, and his case has to be treated differently. There is therefore no discrimination when the matter of promotion, he is treated differently. The least that is expected of any administration is that it does not reward an employee with promotion retrospectively from a date when for his conduct before that date is penalized in presenti. When an employee is held guilty and penalized and is therefore not promoted at least till the date on which he is penalized, he cannot be said to have been subjected to a further penalty on that account. A denial of promotion in such circumstances is not a penalty, but a necessary consequence of his conduct. In fact, while considering an employee for promotion, his whole records has to be taken into consideration. And if a promotion committee takes the penalty imposed upon the employee into consideration and denies him the promotion, such denial is not illegal and unjust. My lord, the para 5 is the conclusion based on this decision. I'll just read and translate it, my lord. ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಮೇಲ್ಕಂಡ ತೀರ್ಪಿನ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸರ್ಕಾರಿ ನೌಕರನ ವಿರುದ್ಧ ಇಲಾಖಾ ವಿಚಾರಣೆ ಅಥವಾ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ಪ್ರಾರಂಭವಾಗಿ ಅಂತಹ ಇಲಾಖಾ ವಿಚಾರಣೆ ಅಥವಾ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆಗಳು ದಂಡನೆಯಲ್ಲಿ ಪರ್ಯಾವಸಾನಗೊಂಡಲ್ಲಿ ಆ ದಂಡನೆಯು ಜಾರಿಯಲ್ಲಿರುವ ಅವಧಿಯಲ್ಲಿ ಅಂತಹ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ಮುಂಬಡ್ತಿ ನೀಡಲು ಆಸ್ಪದವಿಲ್ಲವೆಂದು ಈ ಮೂಲಕ ಸ್ಪಷ್ಟಪಡಿಸಲಾಗಿದೆ. It is clarified that based on the above, that if the disciplinary proceedings result in imposition of penalty, during the penalty period, he will not be considered for promotion, is what is stated. This has been followed. My lord, in fact, this is also barred by delay and latches because
During the penalty period that the promotions had been granted to the other.
no, my lord, in fact, DPC was pending at that point of time. It was in 2015. The case came to be crime number 88 of 2012 was registered in 2012. Thereafter, in 30/12/2015, promotions were given to his juniors when disciplinary proceedings were pending. And then in 2016, articles of charges were issued, my lord. Then in 2019, after the penalty period, he has been promoted. And he has not challenged the promotion given to his juniors also. And in fact, the impugned order notices that he has not challenged the seniority list also. So it's barred by limitation also.
Yes.
Milord, here I am seeking only retrospective effect. Milord, the reason why I am seeking is that I am not challenging that my juniors have been given, I should be given on that count, Milord, on that score. Milord, I am in a score here where I am seeking that the penalty imposed upon me was a minor penalty of deferring the 1 annual increment for 2 years.
In fact, that is exactly his claim.
After finding me guilty.
He
Milord,
says
the
I should be
penalty order
considered
is
along with
8/12
my batchmates is his particular claim. That is wrong contention.
2016 was the penalty order, Milord. And 30/12/2016
Was the penalty.
was the penalty order.
That
My
the
juniors were
juniors-
promoted on 30/12/2015. That is prior to my penalty order,
When the proceedings were.
when the
pending.
proceedings were pending. Now, my lord, the punishment period is also over. 2019, I have been promoted from PC to HC again. Now, my lord, what I am seeking is now the next promotion is, my lord, HC to ASI is pending. HC to ASI, 2022, there is a promotion order.
Now, my lord, since it was a minor penalty, I am seeking that I should be included along with my batchmates in promotion to HC to ASI.
Yes.
That is the representation what I have given. Now, my lord, because it never says withhold one promotion, withholding of promotion or withholding of blood. Since the promotion period was over,
Yes.
my lord, 2018 only the punishment period was over. They should have promoted 2018. My lord, let HC promotion be considered from 2018, my lord. But so far as ASI promotion, my lord, they should have joined along with me, my lord. I should have joined my batchmates. That is the case of the petitions. My lord, on the last occasion, my lord, on the last occasion, I relied on judgment of the Honorable Apex Court, my lord. Last paragraph, that. May I just quote? I
It's here.
think, yes, my lord, same.
Yes.
Paragraph number 15, my lord.
Yes.
My lord, in this, the learned counsel for the respondent submits, by virtue of the punishment imposed, he has not been given his due promotion. We are of the view that the imposition of a minor penalty is not a bar in granting promotion to the respondent. Bar is not a bar in granting promotion. My lord, here, my lord, the minor penalty what they have imposed, my lord, withholding of promotion itself is one penalty there. Now, my lord, if the promotion is denied to me on that day, it will be a double penalty to me, my lord.
Why this is specifically directed to ascertain, is there any provision? Because in some rules, if the penalty, imposition of a minor penalty is not a bar. Censure, imposition of censure, even if you face the entire proceedings and are imposed with a penalty of censure, your promotion cannot be withheld. If the imposition of the minor penalty is not a bar, then it has to be considered. There it is a bar, because the circular clearly says so.
And based on a decision of the Supreme Court.
It is a bar. Yes. But
It's only, my lord, during the penalty period, it's saying now.
correct. It's not the position. Because, like I said, it depends on the rules. The rules in some states, the rules are clear. The rules are provided in the, the issue with regard to consideration after a minor penalty. They find a place in the rules themselves. Here, apparently, it is not in the rules. Even DPC procedure is not rules. It is
Sealed cover procedure is in by way of OML.
executive orders. Now, here is an executive order which says that if the DPC procedure is itself an executive order, nothing prevents the consideration of this issue also in executive orders. There is a circular. There is no rule. Therefore, the circular holds the field. It has to be followed. This petition is filed seeking the following rules. First, the learned counsel for the petition and the learned government advocate appearing for the company. Submitted by the learned counsel for the petition, that the petitioner, who is presently working as head constable, was inflicted with a minor penalty of postponing of annual increment for 2 years by order dated 8/1/2016. It is submitted that thereafter he was promoted as head constable with effect from 26/9/2019. However, his juniors had been promoted to the post of head constable on 30/12/2015. 30/12/2015. It is submitted that the applicant had submitted a representation seeking retrospective promotion to the post of head constable with effect from 30/12/2015, as also seeking further promotion as ASI, taking note of his earlier seniority in the post of police constable. The said representation came to be rejected by Annexure A7,
A4,
A4, endorsement dated
A4 dated, my lord, I'm sorry. It is dated,
A4 endorsement dated 12/9/2023,
yes, my lord.
which was challenged before the tribunal in application number 4524 of 23. The tribunal, after considering the contentions advanced, found that the the petitioner was a person who had faced a disciplinary inquiry and had been inflicted with a minor penalty. It was therefore found that his claim for retrospective promotion at par with his juniors who had not faced such proceedings or suffered such penalty is not tenable. The application was accordingly rejected. The learned counsel for the petitioner submits that since the petitioner had already undergone the minor penalty and since there was no penalty of withholding of promotion, which was imposed as against him, he was entitled for promotion at par with his juniors after the period of the penalty imposed on him was complete. The learned government advocate has placed statement of objections on record. It is stated therein that the applicant, the petitioner herein, had faced the criminal proceedings and had been arrested and sent to and remanded to custody.
Huh?
Uh,
Illa, he was acquitted.
Arrested and, yes, was remanded to custody. That is the contention, remanded to custody. Ultimately, he was acquitted by the City Civil and Sessions Judge, Bangalore City, by order dated 21/9/2015. First, it is contended that subsequent to the registration of the FIR, a departmental inquiry had been initiated against the petitioner and an order was passed on 8/1/2016 enforcing the punishment of postponing of annual increment for a period of 2 years without cumulative effect and treating the period of suspension from 14/3/2012 to 6/7/2012 as such. Full stop. It is contended that while the disciplinary proceeding was pending against the petitioner, his juniors had been promoted as head constables by order dated 30/12/2015. Since the proceedings were pending against the petitioner, he was not considered for promotion, along with his batchmates. Later, after the punishment was imposed and the period of punishment was over, he was promoted as head constable
26/6/2019.
on 26/6/2019. It is submitted that the petitioner, being a person who had faced a disciplinary inquiry and had suffered a punishment, even if it is a minor punishment, cannot claim equation with persons who had not faced such punishment, even if they are juniors to him. It is submitted that the apex court in Jankiram,
Union of India
Union of
versus
India, Janki.
KV Janaki Raman and others.
Vidya was Jankiram and others, had specifically considered this issue and had directed that where an employee is held guilty and penalized and is not promoted, he cannot be said to have been subjected to a further penalty of withholding of promotion. And a denial of promotion in such circumstances is not a penalty. It is submitted that Exhibit R1 circular had been issued by the Government of Karnataka on the basis of the findings of the Apex Court in the above mentioned judgment, wherein it was specifically provided that a person who faces a disciplinary proceeding and imposition of a penalty will be entitled to promotion, will be entitled to consideration for promotion after the penalty period is over. It is submitted that in the instant case, the benefit of consideration for promotion and indeed promotion has been granted to the petitioner after the penalty period is over. It is submitted that in the light of the circular, that as the fact that the petitioner had been imposed with the penalty, the contention that he is entitled to promotion at par with his juniors, which was given at a time when the proceedings were pending against the petition, cannot be accepted. Full stop. Having considered the contentions advanced, the learned counsel for the petitioner relies on a decision of the Apex Court BHPVNL Vidyut Nagar Hisar and others versus Yashveer Singh Gulia to contend that since the penalty imposed against the petitioner was only a minor penalty of deferring of increments, the imposition of such minor penalty is not a bar for granting promotions, and therefore the promotions ought to have been granted from the earlier date itself. We find that there is no such laying down of the law in the decision made available by the learned counsel for the petitioner. The Apex Court only states that the punishment imposed was only barring of one increment without cumulative effect, and that if imposing of the held that if imposing of the minor penalty is not a bar for granting promotion, due promotion shall be granted to him in accordance with the rules and regulations applicable to him. In the instant case, since the government advocate has made available an R1 circular, which specifically provides that the imposition of a minor penalty would be a bar for considering promotions during the existence of the disciplinary proceedings, as also during the period of the penalty. We are of the opinion that the petitioner cannot succeed in this petition. The petition therefore fails in the court.
Vijay Kumar.
Petitioner was the Honorable Tribunal Lord seeking for compassionate appointment on the ground, and the same came to be rejected on the ground that the married daughter, your Lordship's own order, Lords.
When was the
Please, ma'am.
rejection, endorsement? In this case, when was the endorsement?
Yes, ma'am. The father of the petitioner died on 3/11/2017, and the petitioner who was married submitted application on 18/5/2018 within the stipulated time, Lords, and the second respondent rejected her application on 27/7/2018. Thereafter, Lords.
Only this group?
Yes, ma'am.
Married daughter?
Yes, ma'am. And
There is one difficulty, my lord. If the rejection has happened prior to the decision in Bhuvaneshwari Puranik's case, my lord, although the order will operate retrospectively, my lord, my lord, she who did not challenge, Bhuvaneshwari Puranik challenged and she got the relief, my lord. So a closed matter cannot be reopened is my respectful submission.
consider that as well.
Bhim- Bhimeshwar,
When the
yes.
rule stands,
Indeed,
Sorry, no.
my lord, if she had challenged, went on to challenge the rejection on the ground that it is violative of Article 14,
yes.
because in this case, it was already rejected, my lord, before Bhubanesh.
27/7/2018.
Please.
She files the application on
Lord, she filed
2000
application before the tribunal on
2000,
21, my lord, 2021, 4769 of 2021.
9/4/2021, the rules stand amended also.
Yes, please. ಅದರಲ್ಲೇ ಇದೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲೇ ಇದೆ. Date ಇಲ್ಲ.
Bhuvaneshwari Puranik was decided when?
So that, my lord,
one that is reported.
is reported in 2021 itself.
No, thereafter she again approaches the.
Yes,
There is a endorsement on 36/21.
yes, my
which
lord.
is what is
Thereafter,
standard.
once again, my lord, she preferred.
After Bhuvaneshwari Puranik, she again approaches.
Yes,
That again is rejected on 36/21. That is what is considered by the.
File was given.
You want us to record that contention, not in this case. Because in this case, it may not arise because she again approaches.
the order of the,
What I'm saying is if the issue has been closed, it cannot be reopened, Lord, because the question will then arise. How long then, if the matter is closed in 2015, should it be reopened? If it is closed in 2012.
It cannot be, because then it has to be, approach to the tribunal has to be within 1 year. Only those cases.
That is all,
where-
your lordship is understood.
15th December 2020 is the order passed by the learned single judge of this honorable court in Bhuvaneshwari Puranik case. That, my lord,
Taken,
I have annexed it as annexure D, my lord, page 56.
yes, there is a rejection on 36/20. In this case, it may not arise. She brings up this matter
Yes.
before the respondent again reject. 36/21 is what is under challenge.
Yes, ma'am.
Those matters cannot be brought up once again in my.
Probably, which is why the
Because
tribunal,
every old matter will have to be reopened.
yes.
The difficulty I got.
I understand. And the- There is, we have followed the legal provision of the anything that. But they don't do it. No, it has only. It has been stopped on, and then the 9/4/21 rules is also substitution.
But the rules themselves.
Correct. The rules were there. Rules only said married daughter. But married daughter was struck. When they amended, taking away the marriage. Or every daughter will be entitled to consideration. But then the tribunal says that rule is only, that is also not correct. Which is your amendment?
Lord,
Which is the amendment to the rule?
2021, 2021, my lord.
The amendment. It's once the file their reply statement and return.
Ninth April 2021. The amendment,
Produced?
Lord.
Is that produced?
My lord, your lordships have referred it in the judgment itself, my lord, sir.
We have, because I
Yes.
really want to show my brother, that was a different combination. Because that rule also said shall be substituted. Three is correct. not here. Anyway, that's.
Not produced. No.
Heard the learning council. The petition of the learning council. Is submitted by the learning council for the petition. That the issue raised in the petition is covered by several versions of this book, including in the case of Bhubaneswari, the state of that the petitioner is a married daughter of late A.M. Rajendra. What is managed on 2017. Had filed an application in 2018 for appointment at compassionate appointments. The application came to be rejected on 27/7/2018 on the short grounds of checks. A married daughter and is not entitled to appointment under the compassionate appointment rules 1996. Thereafter, she submitted a representation dated 19/4/2021. Seeking the reconsideration of the application. On the grounds that the rules had been amended on 9/4/2021.
Yes, my lord, yes, my lord. That is, my lord, in fact, my lord, the government have contested and filed their objections before the
In your
tribunal.
representation, did you say so?
Yes, my lord.
Yes, on the ground that the rules had been amended from 9/4/2021. It is submitted that the said representation was also rejected by endorsement dated 36/2021, which was challenged before the tribunal. The tribunal considered the contentions advanced, as also the fact that the rules for compassionate appointment stood amended with effect from 9/4/2020. However, on the ground that the rules for giving appointment on compassionate grounds to married daughters is only prospective in effect, the application was dismissed. The learned counsel for the petitioner submits that the rules insofar as they limited the consideration of compassionate appointment only to unmarried daughters stood struck down by the learned civil judge of this court, Bhubaneswari was Puranik. Bhubaneswari v. Puranik was the state of Karnataka. It is contended that with the striking down of the said provision, the requirement that only unmarried daughters could apply for compassionate appointment stood deleted from the rule, notwithstanding the amendment on 9/4/2021. It is submitted that this court in several judgments has considered this point and has held that the that with the striking down of the rule, the applications may have to be considered as if the rules to amended with effect from the very inception of the 1990s. Having considered, the learned contributor submits that concluded cases cannot be permitted to be reopened on the basis of the amended rules or even the judgment of this court. Having considered the contentions advanced, we noticed that what was under challenge before the tribunal was the endorsement dated 36/2021, by which the representation submitted by the petitioner stood rejected. The petitioner had sought a consideration of her case for compassionate appointment in view of the striking down of the rules which limited the consideration only to unmarried daughters. It is not in dispute before us that the rejection of the application for compassionate appointment by the respondents was on the sole ground that the petitioner was a married daughter of the government servant who died in house. In the above actual situation, we are of the opinion that the rejection of the application filed by the petitioner on the ground that the amendment dated 9/4/2021 is only prospective, is not proper. We notice that the offending provision had been struck down by this court in Bhuvaneshwari v. Puran. If that be so, the contention that the amendment dated 9/4/2021 is prospective make no difference to the situation, since the provision which is struck down cannot be relied on by the respondents to reject applications. Is the above view of the matter. We are of the opinion that the petition is entitled to succeed in this petition. The petition is accordingly allowed. The order of the tribunal hearing is set aside. The endorsement dated 36/2021 shall also stand set aside. The respondent shall consider the registrations submitted by the petition, taking note of the eligibility of the petition in accordance with the application preferred on 18/5/2018 without reference to the fact that she is a married daughter. All other issues are left open to be decided by the respondent in accordance with.
Okay. Obliged.
Yes.
21.
Lots, I'm for the petitioner in serial number 21. Lots.
Yes.
Lots, the case of the petitioner is as against the dismissal of his application before the tribunal, Lots. Whereas the prayer of the petitioner, Lots, before the tribunal as well was only for to consider his representations that were filed.
What was your
Lots, my representation was basically this, that I have been appointed in the year 2014, Lots, to the post of Assistant Director Cooperative Audit. And lots, I had secured total marks of 1053.50. And just right above me, lots, was Mr. Balram Lamani, who had scored a total of 1072 marks. And though, lots, the final list was announced in the year 2014, our appointments order came to be issued only in the year 2022. And lots, during this while, Mr. Lamani Malots had opted to take up another examination, and by notification dated 36/2017 Malots, he was appointed to the post of Assistant Commissioner Group A. And that notification also was part of the proceedings, Malots. And subsequently, Malots, I made a representation on 21/4/2023 to respond numbers 2 and 3, seeking my appointment to the said post, since the same has remained vacant, that I am the next eligible candidate to take over that particular position. And when such an representation was made, Malots,
were included in the list?
Malots,
Were included in the list?
yes, my preferential number for the post of Executive Officer Assistant Secretary Panchayat Raj was at serial number 3. And the post that I was allotted to, that is the Cooperative Audit Department, that was at serial number 8. And for these reasons, I had sought, saying that that particular position has remained vacant and that I may be appointed to that particular position. And due to non-consideration of my representations, I went before the KSAT saying that I filed a mandamus seeking seeking my representations to be considered in accordance with law. And my lords, instead the tribunal has dwelt into the merits of the matter. They've basically stepped into, they've continuously relied upon my lords, the judgment in WP 13599 of 2020. That is BG Veeraswamy's judgment, wherein my lords, they say that that is directly applicable to the case in hand. Whereas my lords, in BG Veeraswamy's case, my lords, the candidate in that matter, my lords, had reported to duty, and he had worked in the said post for about 2.5 years, and later on he had resigned. And that is why that position, the person who claimed after him, was not given to him. Whereas in my case, my lords, Mr. Balram Lamani has never participated in the selection process at all. Though, my lords?
He was not appointed, you mean?
No, he was appointed. He was appointed.
Participated in the selection.
Yes. I mean, he was never appointed. He was part of the final selection list. Yes. He was not appointed. So that position has remained vacant. And that is why I had gone before the KSAT seeking only mandamus, my lords.
Is your contention that it would be a non-joining duty vacancy?
Yes, my lords.
Non-joining, the post will carry forward, number one. And second one is, I request my lordship to come to page number 6 of the improved order. Page 25. I will read from 24 minutes.
Yes.
To like up the oral arguments, we have there last two lines.
Yes.
Of prolonged various litigation filed before the tribunal, High Court and the Honorable Supreme Court. Ultimately, the government enacted the act called Karnataka Civil Services Validation of Selection and Appointment of 2011 Batch Gazetted Commissioners Act 2022 and issued the appointment orders. The relevant portion in the Act 2022, that is Section 3A, reads as under. 2011 Batch Gazetted Commissioners selection made by the Karnataka Public Service Commission shall be valid in accordance with law. In Section 3C, the state government shall take immediate steps to issue appointment orders to 2011 Batch Gazetted Commissioners as per the Karnataka Public Service Commission selection list. 3E. This is important, my lord. No suit or other proceeding shall be maintained or confirmed in any court or any tribunal or before any authority for the review of any such appointment made in accordance with the provisions of this act. My lord. And in this para 7, my lord, by fourth line, it is pertinent to note that the Act of 2022, in spite of 2011 batch, the government not provided any provision for altering the list. No doubt, Sri Balram Lamani was reporting duty for various reasons. Was not reporting duty for various reasons, as he was appointed in some other post. My lord, earlier selection was in year 2011. For so many reasons, my lord, the Validation Act came into force, and according to that, my lord, once he has not reported, he has participated in all the things, he has not reported. And that post will carry forward, my lord. It cannot be given to any other person. That is the standard, the tribunal, finding of the tribunal is.
Yes.
Hence, I request
No, my lords.
This application does not survive for determination because the infractors about judgment is aptly applicable in this case. Yes, unless there is a right, there is no corresponding duty to consider. Therefore, first you must, even if when you're seeking a writ of mandamus, you must first establish your right. Only saying that I've only made a representation, whatever, if you make a representation which is not permissible with the allowing of which is not permissible according to the act, according to law, there is no right, there is no corresponding duty of the respondent to consider your application.
No, my lords, there's a judgment of this honorable court as well in GK Nagendra, my lords, Nagendra GK's verdict, wherein, my lords, the court talks in length as to how a vacancy has to be fulfilled with. And that order now, my lords, stands confirmed by the Supreme Court as well.
Is that applicable to?
Yes, my lords, it is absolutely applicable.
The vacancy, what the division bench held was, if he has not participated in selection process, like physical standards, certificates, etc., etc. Then after publishing the final select list and issuing the appointment order, after passing through all these stages, then that post has to be treated as a fresh vacancy.
Consider this. Consider.
Clearly
If
maintained.
you want to argue, we can hear it on some other day. Yes.
Yes, a date may be fixed to that effect, my lords. If whatever is convenient to the court.
Yes.
5th September.
5th September, my lords.
Mohammed Shami.
It's 22. The petitioner is a public service commission. Short point, my lords. Experience qualification of 1 year was prescribed. Recruitment to the post of motor vehicles inspector.
Yes.
The recruitment rule provided, my lords, for a qualification amongst other things, diploma qualification and experience of 1 year in a reputed automobile workshop. The only question, my lords, is whether the experience qualification, his qualification that he has is 1 year qualification is prior to 1 year, he is acquiring the basic qualification, education qualification. So that
There is a provision in the rules.
there is no, there is a, rules just say that qualification, there
There is a provision in the general rules which say that the experience qualification must be after acquiring.
it does not say so, my lords. There's one Kerala High Court judgment, division bench judgment, which
is-
where this, the,
Different because there is a specific provision. in
there's
the
a
general-
specific provision, but still, my lords, there is also an observation in that judgment, which says that even in the absence of that also, in terms of the Supreme Court judgment, unless it is specifically provided, my lords, that it could be prior to, so it is only few dates, my lords, we can initiate. Please. My lords, may kindly see page 67, my lords.
Yes.
Inspector of Motor Vehicles in the Department of Transport. Minimum general qualification of a pass in 10th standard, not in dispute, my lords, and must be a holder of a diploma in automobile engineering of 3 years duration or diploma in mechanical engineering of 3 years duration awarded by the State Board of Technical Education, which is what the original applicant has, or a degree in automobile engineering from a recognized university or a degree in mechanical engineering from a recognized university, and 3, my lords, working experience of at least 1 year in a reputed automobile workshop which undertakes repairs of both light motor vehicles, heavy goods vehicles, and heavy passenger motor vehicles fitted with petrol and diesel engine. Note, reputed automobile workshop means workshop which undertakes repairs of both light motor vehicles, heavy motor vehicles, and heavy passenger motor vehicles fitted with petrol and diesel engine. Now, kindly see, my lords, at page 121.
Yes.
List of rejected candidates, my lords, this was published on 4/2/2016. Lords, the date may be noted, it's relevant. And my lords, at 141, at page 141, my lords, in that notification. Last entry, serial number 449, my lords. Sridhara,
141.
141.
Serial number 449.
Yes.
Sridhara. Next page, my lords, we say remarks. As per RTO report, no experience. Now kindly see, my lords, his degree certificate and his experience certificate, which are at page number 275 and 276. Two 275, my lords. This is the diploma in automobile engineering, but at the end of the certificate above the signatures and completed diploma
December 1990.
1999.
Yes.
Now
experience
next page,
certificate is
next page, my lords. 3/8/1999 to 25/8/2000.
you take it from only from 24/12/1999.
Then 1 year is not there. If it was anything more than that, my lords, it could have been considered. Now 2 judgments, my lords.
Notes, one is the Supreme Court judgment 1991 supplement 1 SCC 367. And another one is the Kerala High Court Sirajuddin judgment.
There is a specific provision that says that in all cases.
Please.
Where the qualification of experience is prescribed, it must be one acquired after.
There was a specific provision, my lords, in one of the rules. Kindly see, my lords, the Supreme Court judgment first. My lords, in page 371, placetum E, my lords, on the left side. 371, last but one page. 371 placetum E. Normally, when we talk of experience, unless the context otherwise demands, it should be taken as experience after acquiring the minimum qualification required, and therefore necessarily will have to be posterior to the acquisition of the qualification. Placetum E.
Here also, there was a provision, experience acquired after obtaining the prescribed academic qualification only will be taken into.
Please, my lords. But what the court has said is, normally, unless any other interpretation, in normally we talk of an experience, unless the context otherwise demands, placetum E, my lords, it should be taken as experience after acquiring the minimum qualification required, and therefore necessarily will have to be posterior to the acquisition of the qualification.
Yes.
Now, my lords, in the Kerala High Court judgment, notes that was also in the context of the same motor vehicles, motor vehicle inspectors. It is with regard to the very same qualification that is prescribed in the central government. My lords, may kindly see in para 5, extract, my lords, of appointment of motor vehicles, my lords, as per.
Yes.
Please.
Yes.
In para 5, my lords, they have extracted, my lords, section 213 of the Motor Vehicles Act, which provides, my lords, the qualification therein. Then in para 9, the Kerala High Court, the Kerala rules, my lords, has been extracted.
Yes.
Now kindly see, my lords, at para 11 is the finding, which I am relying upon.
Yes.
We also indicate that then we read together the notification framed by the central government under section 2134 of the Motor Vehicles Act and rule 10AB, the requirement that the working of experience should be gained after acquisition of basic qualification is a mandate requirement. In this case, we may also refer to the decision of the apex court in so and so, wherein the apex court has held that normally when one talks of an experience, unless the context otherwise demands, it should be taken as experience after acquiring the minimum qualification required, and therefore necessarily will have to be posterior to the acquisition of qualification. In view of the mandated mentioned legal portion, we are of the view that we have to read the qualification laid down by the central government along with the general qualification laid down in so and so, in the event of which the working experience gained by an applicant must be after the acquisition of the basic qualification. Applicants do not appellants do not satisfy the above requirement and therefore not eligible to apply for the post of motor vehicles inspector. Notes, my submission is this: though we don't have a similar provision as per Rule 10AB in the state of Karnataka, notes, the general principle is that it should be unless the context otherwise requires. So that is the notes, reject list was on 4/2/2016. Original application was filed on 27/3/2023.
Yes.
And in the original application, he has not produced the diploma mark certificate, which showed the date. So therefore, my lords, the tribunal has actually, kindly see the findings, my lords, for a moment. At page number 24.
Yes.
Lords, fourth line. It is fourth line from the top, or notes page 23, my lords, last para. We are of the considered view with regard to the reply statement and the averment made by the learned counsel for the KPSC at the hearing, that there is serious attempt to mislead this tribunal on the appreciation of the facts itself with the pleadings and averments that are contradictory as detailed above. It is not the case of the respondent KPSC that the applicant is not having the requisite experience of at least 1 year. That was our exact contention. It is a contention of the respondent KPSC during the hearing that the experience is prior to obtaining of the academic qualification, which contention is untenable on the facts with regard to the date of securing of the academic qualification and the service experience. This is the incorrect finding of fact, my lords. And my lords, finally, the court has in fact also gone to impose a cost of 10,000 in the Public Service Commission, my lords, and it should kindly see the consequential directions that they've issued from para 27 onwards, from page 27. That is the operative portion.
Yes.
The impugned select list dated so and so at annexure A13 is quashed to the extent it has excluded the applicant from consideration. It shall therefore be reviewed for inclusion of the applicant in the appropriate portion in the select list with regard to his merit and GM XMP reservation category claimed by him, and fresh select list shall be notified. Time for compliance for notification of review select list, including the applicant in the select list, leading to consequential alterations of persons included in the select list as may be necessitated is 2 months from the date of the order. It is made clear that the review of the select list of so and so, as at annexure A13, as directed supra, shall not affect the merit list of persons in the said impugned list up to and inclusive of serial number 92 of the impugned select list, who are all having higher merit than the applicant, which is 35.12, and the review of the select list cannot alter their inter se positions in the review select list in any matter whatsoever. The fourth respondent shall be entitled for inclusion in the review select list based on the review aforesaid, and if he is included in the review select list, his appointment to the service, if already done, shall not be rescinded. Otherwise, his non-inclusion in the review select list will lead to necessary consequence of his discharge from service if he is already so and so.
It is your case that in all cases under this selection at least,
Please, Milord.
you are taking only the qualifications after the, the experience after the.
After, please, Milord.
Continue after lunch.
Please.
Please.
Please. That will settle the issue.
My lords, bill number 23, my lords, kindly grant week time 23.
Who appears against you?
I'm appearing for respondent.
Serial number
23.
23. Yes.
May I make a motion? Lord, serial number 26, my lord. Objection is ready, my lords. Have to get the signature from the authority.
Petitioner.
Date after 22nd is, I'll get the signature and file.
28th.
23rd, madam. Because only discharge of probationary, madam, stigma. 23rd or 22, but
22nd, after any date after 22nd.
23rd, 28th, 29th, 7th.
27. Much.
Like,
Court officer? Court officer? Court officer? Court officer? Court officer? Court officer. Court officer. Court officer? Court officer?
ಹಾ ಹೇಳಪ್ಪ. ಇಲ್ಲ ದಿನ ಬಂದಿಲ್ಲ ಹೇಳಪ್ಪ. ಹಾ ಹಾ ಏನ್ ಹೇಳಿದ್ರು? ಏನಂತ? ಹಾ ಹಾ ಹ್ಮ್
ನಾನ್ ಹೇಗ್ ನೋಡ್ಕೊಂಡಿದ್ದೀನೋ ನನ್ ಮಗಳನ್ನ ನೀವು ಒಂದ್ ಹೆಜ್ಜೆ ಒಂದ್ ಮುಂದೆ ನೋಡ್ಕೊಂಡ್ರೆ ಸಾಕು ಅಂತ ಹೇಳಿದ್ರು.
ಆತ್ ಬಿಡಪ್ಪ ಅನ್ಬೇಕಾಗಿತ್ತು.
ಆಯ್ತಪ್ಪ ಅಂತ ಹೇಳಿದ್ವಿ.
ಹಾ
ತೋರಿಸ್ದೆ ಎಲ್ಲ ಇದು ಅಪ್ಪಂದು ಇದು ಕ್ಯಾಬಿನ್
ಹ್ಮ್
ಇದು ಮಾಡೋರಿಗೆ
ಹ್ಮ್ ಹ್ಮ್
ಅದು ಅದೇ ಇದು ಸ್ವಲ್ಪ ಮೈನರ್ ರಿಪೇರ್ಸ್ ಇದೆ.
ಹಾ
ಅದೇ ಎಲೆಕ್ಟ್ರಿಷಿಯನ್ ಮೈನರ್ ರಿಪೇರ್ಸ್ ಇದು ಎಲ್ಲ ಸ್ವಲ್ಪ ಲೈಟಿಂಗ್ ಇದೆಲ್ಲ ಮಾಡ್ಕೊಬೇಕು ಅಂತ ಹೇಳಿದೆ. ಮೇಂಟೆನೆನ್ಸ್ ಇವರೆಲ್ಲ ಬರ್ತಾರೆ ಮಾಡಿ ಹೋಗ್ತಾರೆ ಇದು ಅಂತಾನು ಎಲ್ಲ ಹೇಳಿದೆ. ಹಾಗೆ ಅಂತ ನನ್ಗೂ ಆಫೀಸ್ ಇದೆ ಇವಾಗ 3 ಗಂಟೆಗೆ ಹುಡುಗರು ಕಾಯ್ತಾ ಇದ್ದಾರೆ. ನೋಡ್ಕೋಬೇಕು ಇದು ಮಾಡ್ಕೋಬೇಕು ಅಂತ ಅಂದ್ರು. ಆಗ್ಬಿಟ್ಟು ಇನ್ವೈಟ್ ಮಾಡಿದೆ. ಲಂಚ್ ಬ್ಯಾಕ್ ಸೈಡ್ ಇದೆ ಇದ್ರ ಗೊತ್ತಾ? ಇಲ್ಲ ಬ್ಯಾಕ್ ಸೈಡ್ ಇದೆ ಇದ್ರ ಗೊತ್ತಾ? ಲಂಚ್ ಹೋಗ್ಬೇಕಾ ಲಂಚ್ಗೆ ಹೋಗೋಣ ಅಂತ ಅದೇ ಗಡಿಯಾರ ನೋಡ್ಬಿಟ್ಟು ಗಡಿಯಾರನ ನಿಲ್ಸ್ಬೇಡಿ ದಯವಿಟ್ಟು. ಗಡಿಯಾರನ ಸೆಲ್ ಹಾಕಿ ಓಡಿಸಿ ಅಂತಂದ್ರು.
ಇಲ್ಲ ಅದು ಎಷ್ಟ್ ಹಾಕಿದ್ರು ಓಡ್ತಾ ಇಲ್ಲ ತೆಗಿತಿದೀವಿ ಅಂತ ಹೇಳ್ಬೇಕಾಗಿತ್ತು.
ಹಾಗೆ ಅಂತ ಮಾಡಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ. ಹೇಳಕ್ಕೂ ಮೇಲೆ ಕೂರ್ಸಿದ್ದೆ ಲೈಟ್ ಹಾಕಿ ಮಾತಾಡ್ತೀನಿ. ಲೈಟ್ ಹಾಕಿ ಫ್ಯಾನ್ ಹಾಕಿ ಮಾತಾಡ್ತೀಯಲ್ಲ ಅದು ಹಿಂದ್ಗಡೆ ರೋಡ್ನಲ್ಲಿ ಜಾಸ್ತಿ ಹೋಗ್ತಿರುತ್ತೆ ಎಲ್ಲ ಇಂಡಸ್ಟ್ರಿ ಇದು ಓಡಾಡೋದು ಡೈಲಿ ಓಡಾಡೋ ರೂಟೇ ಇರುತ್ತೆ. ಹಿಂದ್ಗಡೆ ರೂಟಲ್ಲಿ ನಾನು ಜಾಸ್ತಿ ಓಡಾಡೋದಿಲ್ಲಿ. ಆಮೇಲೆ ಇಲ್ಲಿ ಇದು ಇಂಡಸ್ಟ್ರಿ ಸಪ್ಲೈಯರ್ ಇದು ಎಲ್ಲ ಇಲ್ಲೇ ಇರ್ತಾರೆ ನನಗೆ. ನನ್ಗೆ ರೆಗ್ಯುಲರ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಏರಿಯಾ ಇದು. ಅಂತಂದ್ರು ಅಂತಂದೆ ಹಾಗೆ ಅಂತಂದ್ರು. ಅದನ್ನ ಅಂತಂದ್ರು.
ಮತ್ ಲಂಚಿಗೆ ಏನಂದ?
ಲಂಚಿಗೆ ಇವಾಗ ಏನು ಬೇಡ ದಯವಿಟ್ಟು ಜಸ್ಟ್ ನಾನು ಮಾಡ್ಕೊಂಡೇ ಬಂದೆ. ಈಗ ಬರ್ಬೇಕಾದ್ರೆ ಇನ್ನೇನು ನಮ್ಗೆ ಬಂದೆ ಹಾಗೆ ಅಂತ. ನಾನು ಈಗಿನ್ನೂ ಬಂದೆ ಜಸ್ಟ್ ಸೆಟಲ್ ಡೌನ್ ಆಗ್ತಾ ಇದ್ದೆ ಅಷ್ಟೇ. ಅಷ್ಟೇ ಬಂದ್ರಿ ನೀವು ಇವಾಗ ಹಿಂಗೆ ಅಂತ ಮಾತಾಡಿದ್ರು.
ಹೋದ್ರ
ಚೆನ್ನಾಗಿ ಮಾತಾಡಿ ಹೋದ್ರಪ್ಪ.
ಅಷ್ಟೇ ಅಂದ್ರೆ ಅಲ್ಲಿಗೆ ಎಲ್ಲಾರ್ದು ಒಪ್ಪಿಗೆ ಆಗೈತಿ ಅಂತ ಅರ್ಥ.
ಹೌದಾ? ಒಪ್ಪಿದಾಳೆ ಅಂತ ಆಗ್ಬೇಕಲ್ಲ.
ಯಾರು ಯಾರು ಅನ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ
ಮದ್ವೆಗೆ ಹಂಗಿಲ್ಲ ಏನಂದ್ಲಿಲ್ಲ ಮತ್ತೆ ಹೆಂಗೆ ಅಂತ ನಾವು ಅಪ್ಪನ ಹತ್ರ ಮಾತಾಡ್ತೀನಿ ಅಂದ್ರು. ಆಯ್ತು
ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡು ಮಾತಾಡಿ ಸರ್.
ಫೋನ್ ಮಾಡ್ತೀನಿ ಅಂತಂದ್ರು. ಆಯ್ತಪ್ಪ ನೀನ್ ಯಾವಾಗ ಮಾಡು ಅಪ್ಪ ಫ್ರೀ ಆದಾಗ ಬೇಕಾದ್ರೆ ನಾನೇ ಒಂದ್ ಮೆಸೇಜ್ ಹಾಕ್ತೀನಿ ನಿಂಗೆ. ಅಪ್ಪ ಇಲ್ಲ ಅದೊಂದ್ ಸ್ವಲ್ಪ ಅದೊಂದು ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ಹಾಕೊಂಡಿದ್ರು. ಕೋರ್ಟಿಗೆ ಹೋಗಿದ್ದಾಗ ಅದೊಂದು ಮೀಟಿಂಗ್ ಹೋಗ್ಲೇಬೇಕು ಅಂತಂದ್ರು. ಇಲ್ಲಾಂದಿದ್ರೆ ಪೋಸ್ಟ್ಪೋನ್ ಮಾಡ್ತಾ ಇದ್ದು. ಬರ್ತಾರ ಫ್ಯಾಮಿಲಿ ಇದು ಅಂತಂದ್ರೆ ಫ್ಯಾಮಿಲಿಗೆ ಇಂಪಾರ್ಟೆನ್ಸ್ ಕೊಡ್ತಾರೆ ಆತರ ಮಾಡಲ್ಲ. ಹಾಗೇನಿಲ್ಲ ನಿಮ್ದು ಲಾಯರ್ಸ್ ಡಾಕ್ಟರ್ಸ್ ಟೀಚರ್ಸ್ ಪ್ರೊಫೆಷನಲ್ಸ್ ಯಾವಾಗ್ಲೂ ಈ ತರ ಒಂದ್ ಟೈಮ್ ಇದು ಎಲ್ಲ ಕೊಟ್ಟಿರ್ತೀರಾ ತಾವು. ಇಲ್ಲ ಜನ ಊರಿಂದ ಹೊರಗಿಂದ ಬರೋರೆಲ್ಲ ಬಂದಿರ್ತಾರೆ ಮಾಡ್ತಾರೆ ಎಲ್ಲ ಹೇಳಿದ್ರು. ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಡೈಲಾಗ್ಸ್ಗಳು ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಹೇಳಿದ್ರು ಹಾಗೆ ಅಂತ. ಸಣ್ಣ ಒಪಿನಿಯನ್ ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ಬಂದು ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ತೀರಾ ಏನು ಅಂತ ನಾವೇನ್ ಕೇಳ್ತೀರಾ ಮಾಡ್ತೀರಾ ಅಂತ. ನಮ್ದು ಅವೆಲ್ಲ ಏನು ಆಸೆ ಇಲ್ಲ ನೋಡಪ್ಪ. ಮದುವೆ ಆಗಿ ಚೆನ್ನಾಗಿ ಬದುಕಿದ್ರೆ ಸಾಕು. 2 ಮನೆ ಒಂದಾಗ್ಬೇಕು ನನ್ಗೆ. ಸುಮ್ಮನೆ ಬಂದ್ಬಿಟ್ಟು ಮನೆ ಹಂಗೆ ಹಿಂಗೆ ಅಂತ ಮಾಡೋದಲ್ಲ. ನಾನೇನು ಎಕ್ಸ್ಟ್ರಾ ಆಗಿ ಡ್ಯೂಟಿ ಆಗಿ ನಾನೇನು ಬರ್ತಿಲ್ಲ ಯಾವತ್ತು. ಮಾಡಿದ್ರು ಕಷ್ಟಪಟ್ಟು ಬರ್ತಿರೋದು ಅಂತ ಹೇಳ್ತೀನಿ. ಎಲ್ಲ ಅಪ್ಪನ ಶ್ರಮ ಅಪ್ಪನ ಹೆಸರು ಇರೋದು. ಅದನ್ನೇ ಬೆಳೆಸಲಿಕ್ಕೆ ನಾನು ಮಾಡ್ತಾ ಇರೋದು ಅಂತ ಹೇಳ್ತೇನೆ. ಮಾತಾಡ್ಕೊಳ್ಳಿ, ಏನೋ ಫ್ರೀಯಾಗಿ ಮಾತಾಡ್ಕೊಳ್ಳಿ. ಏನೇ ಇದ್ರು ಮಾತಾಡಿ, ಹಂಗೇನಿಲ್ಲ ಅಂತಂತು. ಎಲ್ಲ ಹೇಗ್ ಮಾತಾಡಕ್ ಇರುತ್ತದಪ್ಪ. ಪರ್ಮಿಷನ್ ಕೊಡ್ತಾರೆ ತಕ್ಷಣಕ್ಕೆ ನಾವು ಏನ್ ಬೇಕಾದ್ರೂ ಮಾಡಕ್ಕಾಗುತ್ತಾ?
ಅದ್ ಸರಿ, ನಂಬರ್ ಇಲ್ಲಲ್ಲ.
ನಂಬರ್ ಇಲ್ಲ, ನಾನು ಕೇಳಿಲ್ಲ, ನಾನು ತಗೊಂಡಿಲ್ಲ.
ಮತ್ತೆ
ಅವ್ರ ನಂಬರು ನಾನು ಮಾವದ್ದು ನಂಬರು ನಾನು ಇಟ್ಕೊಂಡು ಇಲ್ಲ.
ಫೋನ್ ಮಾಡಿದ್ರು ಹಂಗೆ ಬಂದ್ರ?
ಫೋನ್ ಮಾಡಿಲ್ಲ, ಹಂಗೆ ಬಂದ್ರು, ನೇರವಾಗಿ ಡೈರೆಕ್ಟ್ ಆಗಿ ಬಂದ್ಬಿಟ್ರು.
10 ಗಂಟೆ ಬಂದ.
ಬಂದ್ರು,
2 ವೀಲರ್ನಾಗ ಬಂದ.
ಬಂದ್ರು, ನಾನೀಗ ಗೊತ್ತಿದ್ದಿಲ್ಲ. ಬಂದ್ರು.
ಅಂದ್ರ ಅಲ್ಲಿ ಅಷ್ಟೊತ್ತಿಗೆಲ್ಲ ಲೊಕೇಶನ್ ಗಿಕೇಶನ್ ಎಲ್ಲ ನೋಡ್ಕೊಂಡು ಹೋಗವನೆ ಅಂತ ಅಲ್ಲಿಗೆ.
ರೋಡೆ ಅಂತೆ ಎಷ್ಟು ಒಂದು ಸಾಕು.
ಎಲ್ಲಿ
ಈ ವಿಜಯನಗರದ ಸ್ಟ್ರೈಟ್ ಹೋಗಿ ಲೆಫ್ಟ್ ಅಲ್ಲಿ ರಿಲ್ಯಾಕ್ಸ್ ಇದೆ ಅಂತಿಲ್ಲಿ. ನಾನು ಏನ್ ಮಾಡಿದ್ದೀನಿ ವಿಜಯನಗರದ ಯಾವ ಪಕ್ಕದಲ್ಲೇ ಇರೋದು ಆಫೀಸ್. ಮತ್ತೆ ಬರ್ತೀವಿ ಹೋಗ್ತೀವಿ ಅಂತ ಹೇಳ್ತು. ಮಾತಾಡಿದ್ದಾಯ್ತು.
ಇನ್ನೇನ್ ಮುಗೀತಲ್ಲ ಬಾ. ಡ್ರಾಪ್ ಆಫ್ ಕ್ಲೋಸ್.
ಪಾಸಿಟಿವ್ ಒಪಿನಿಯನ್ ಬರುತ್ತೆ ಸ್ವಲ್ಪ. ಸಂಡೇ ಅವರೇ ಹೇಳಿದ್ರು. ನಿನ್ನ ಹತ್ರ ಫೋನ್ ಫೋನಲ್ಲಿ ಮಾತಾಡ್ಕೊಂಡು ಇನ್ನೆಲ್ಲ ಮುಂದೆ ಮಾಡಿಸ್ತು ಬರ್ತೀನಿ ಅಂತ ಅಂದ್ರು. ನಮ್ಮ ಒಪಿನಿಯನ್ ಇದು ಕೇಳ್ಕೊಂಡು ಹೋಗೋದಕ್ಕೆ ಅದೇ ಮೇನ್ ಅವ್ರದ್ದು. ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ತೀವ
My lords. Vote is muted, my lords, can't hear. Serial number
Yes.
44, my lords.
44 time granted.
Relevant documents to be.
The short date.
Yes, yes.
29th,
Select
29th,
grateful, my lords.
46.
Not before the case, the private response remained underrepresented. Therefore, I could not serve I personally served on them, failed acknowledgement also not place even that. And yesterday
Yes.
it was adjourned from the instance of the council for the government advocate that he get instructions regarding the posting giving these
List on next week Sunday. Yes, show the name and list it. Show the name of the council and list it. We'll have it next week.
ಅವ್ರ ಹೆಸರು ಹಾಕಿದ್ರು ಸರ್ ಇದ್ರಲ್ಲಿ
short date please.
ಸರ್ ಅವ್ರ ಹೆಸರು ಇದೆಯಾ ಇದ್ರಲ್ಲಿ ನೇಮ್ ಆಫ್ ದ ಅಡ್ವೊಕೇಟ್ ಇದೆಯಾ
Advocate ಇಲ್ಲ, remained
Yes, remained unrepresented. All right, list it. We'll hear it. GP, please get instructions with regard to postings.
Short date maybe
Yes,
29th,
29.
list it on
Next week,
14th.
not it.
14th.
14th,
48.
47.
47.
That appear, my lords. Office objection is only with regard to translation. Relevant portions have produced, my lords. Office
Special orders
objection
can be listed for admission.
that your lordships have already granted an interim order. They have already filed vacating. Will have to be heard.
We'll list it on a short date. Not today, not today. We are already at 3:15, no point passing it over today. List it on, yes,
14th.
Let's 14.
then on some other day.
19th or 21st. my lords.
29th.
Yes,
Interim order.
till then.
48.
At 48, my lord, I moved yesterday, my lord, it's a fresh matter. Or my lord, question, my lord, the order passed by the Karnataka Administrative Tribunal. My lord, the translation copies are ready, your lord. The office objection is.
Give it to be served.
Hmm?
Give it to somebody.
I not sir.
Can we have this on Monday? What is the matter about?
Right, the petitioner, your lordship.
Just a transfer. There's an order as against him by the Lokaita where there was disproportionate assets. Therefore, he was suspended. Suspension at time was lifted, and he moved this Honorable High Court to state that at least give me a posting. And contempt was filed. So the department said, no, we'll give him a posting. Subsequently, now they're trying to give him the same posting to the same chair where he held, where he took the bribe. One is that he can't be given an executive posting while during the inquiry that is pending. And two is the lady that is whom we're representing. She was put in his place at that point of time where he was suspended and there was a transfer order. Now overnight, they're trying to remove her. Fortunately, the Honorable the tribunal came to her rescue.
The,
and
the
passed-
challenge is only with regard to suspension?
May
Or is
I
it
submit,
with
my
regard to
lord?
transfer also?
I may be given opportunity being in a petitioner council, my lord. My lord, the petitioner, my lord, is a employee of KDB. My lord, he was, my lord, under my lord, criminal case launched against him under section 13 of the act. That is one part. This honorable court in a suspension order made a revoke and directed the KDB to give a posting to me. Whereas the respondent is from the PWD, the deputy NH.
We'll have this, have this on Monday in the admissions list. 14th. 14th. in the-
45, serial number 45, my lord. In the preliminary hearing, your lord. In the preliminary hearing.
Will come in preliminary.
Yes. There just be an observation. We have an order in our favor from the tribunal over which they have come before this honorable court. Despite that order, he's still squatting on that chair.
Till on 14th, we'll hear it.
Please.
Yes.
Serial number 45, my lord. It's a matter relating disciplinary proceedings, my lord. KPSC advocate may be directed to take notice. Relevant translations, I will file it, my lord.
Yes.
KPSC advocate may direct it. I will file it.
29th, sir. Hearing on IA, still number 49.
Matter relates to the suspension, my lords. The order of suspension is dated 15/10/2022, my lords. 15/10/2022 is the order of suspension.
And proceedings are on?
My lords, disciplinary proceedings are going on. My lords, I went before the tribunal. Tribunal, my lords, granted me an interim order, then rejected. I am before your lordships, my lords, in a separate proceeding where your lordships have granted an interim order, my lords. But at any rate, my lords, from 15/10/2022, my lords, I am under suspension, my lords. And my lords, I have not been paid subsistence allowance. My lords, these are under the Police Act. My lords, the order is passed admittedly by an in-charge officer. My lords, criminal proceedings are quashed. Your lordships may kindly have a look at the order sheet, my lords, and if your lordships would.
When? 14th,
2:30.
it's on 14th, 2:30.
Great.
All the past overs first. Means first. First overs.
Passed on matters. Still number 7, government advocate.
Twenty-two was continuing. 22. It was in the middle of.
Yes.
Because it was.
Yes,
half.
let
Serial number 22. Please.
let that continue.
Please.
ಅರ್ಧನ ಆಗಿತ್ತು ಸರ್ ಅದು ಅರ್ಧಕ್ಕೆ ನಿಂತಿತ್ತು.
It is going. That's one submission. Notes, there is one development I just want to bring to the notice of the spot. Notes, there's a division bench judgment in the context of this recruitment. What had happened, my lords, was that large number of experience certificates, my lords have seen, it was not about 1 year. It provided diesel engine, petrol engine, and all these kinds of things. So a large number of experience certificates were rejected by the Public Service Commission. So petitions were filed before the Karnataka State Administrative Tribunal, a batch of petitions challenging the rejection, which was in the earlier round when the initial list was published. So, my lords, but in the meantime, the central government, my lords, had amended after the recruitment notification last date was over, amended by virtue of a notification the central regulations whereby the 1 year prescription was taken out. So the tribunal, after hearing the matters, held that since subsequent notification that as the 1 year prescription is taken out, so therefore that 1 year can be done away with, the entire process can be redone without looking into the experience certificate. No, but in that order was challenged, my lords, by the state and the KPC and several other persons because that was subsequent to the last date of note. And this honorable court, my lords, in that matter, set aside the order of the KSAT. And then insofar as the experience certificates were concerned, there was some issue with regard to the diesel engine, petrol engine workshops, because it says it has to be in all those workshops. So the state, KPSC had written to the state government with regard to how these experience certificates have to be considered. State government had written a letter to them stating that you can consider all the experience certificates except 16 persons whose experience certificates were prior to their qualification. So a query was posed, my lords, that whether it was uniform in nature. That fact has been recorded in a division bench judgment, my lords. So I'll just pass it on. Notes, if my lord say page 57 minutes. Page 35 minutes is the questions that were posed, is the points for consideration, page 35. I'll just read that note. Whether the order dated so-and-so passed by the Karnataka State Administrative Tribunal, Bangalore in application number so-and-so requires to be sustained or set aside, what order? Now kindly see page 57 minutes. Para 33, it in the instant case, it is noticed at the cost of repetition that the recruitment process for selecting the inspector of motor vehicles was commenced by issuance of the notification dated 4/2/2016 as per the extant rules of 2013. The condition that has been prescribed therein was 1 year work experience for the post of motor vehicles inspector. As already noticed here in above, the central government by notification dated so and so, which had prescribed the work experience under its earlier notification dated, had deleted the same by substituting the same by issuance of notification dated 8/3/2019. In other words, substitution came when the recruitment process was midway, or by which time the applications had already been called for, written examination had been concluded, verification of documents had taken place, and KPSC was in the process of publishing the provisional list of candidates. Hence, at that juncture, rules of the game could not have been changed even at the instance of the recruiting authority. The criteria for selection cannot be altered or tinkered by the authorities concerned in the middle or after the process of selection had commenced. On the basis of this, my lords, order of the tribunal was set aside. But now kindly see page 61 minutes regarding the how the experience certificates at point number 2. The secretary KPSC by affidavit dated so and so had stated during the recruitment process, KPSC had sought clarification from the government about acceptance of experience certificates produced by the candidates, and Government of Karnataka by its communication dated 19/3/2020 has informed the KPSC that experience certificate produced by all the candidates should be treated as sufficient, subject to fulfillment of other eligibility conditions and exclusion of acceptance certificates produced by 16 candidates who are said to have acquired working experience prior to their acquiring academic qualification, and 2 candidates whose experience certificate shows less than the minimum stipulated experience of 1 year. Hence, it has expressed its agreement with the view expressed by the state government. Subsequently, on so and so, Additional Commissioner for Transport Admin, Bengaluru, had also filed an affidavit stating thereunder that it had intimated the KPSC to accept the certificates provided by all the candidates relating to the experience as eligible, subject to exceptions mentioned in its communication dated 19/2020, with an intention to conclude the process of selection is as much as 300 posts of motor vehicles inspectors are lying vacant as against 430 sanctioned floors, and pleading that the department is facing difficulties in day-to-day administration of work and enforcement activities. It has also stated that the acceptance of experience certificate by the KPSC is only for the purpose of completing selection process based on the marks obtained or merit of the candidates for appointment, and such acceptance of such certificates would be subject to verification and same being in conformity with the Cadre and Recruitment Rules 2013 at the time of considering appointment of the candidates. It was also stated that the verification of the certificates produced or attached along with the applications would be carried out at the time or before the issuance of the appointment letters, and said exercise would be undertaken by the Deputy Commissioner of the respective districts in order to satisfy not only the requirement prescribed under the Cadre and Recruitment Rules are met, but also to allay the apprehension that has been expressed by the petitioners. Said affidavits are placed on record. For the reasons aforesaid, we proceed to pass the following order. Then, my lords, Roman 4 may kindly be seen. We direct the Karnataka Public Service Commission to consider the certificates produced by the candidates as indicated in affidavit dated 2/2/2021 and proceed with the recruitment process in accordance with the recruitment notification dated 4/2/2016 and in accordance with law. So therefore, my lords, not only for petitioner, it was for all 16 of them. So therefore, that concludes the issue.
Yes. Yes, what is?
Respondent number 1 is the reserve for ex-service candidate. 5 posts. Page number 67. 127 posts are there, 5 posts are ex-service. My contention is there. Yep.
Page.
Page number 270. Now got the experience certificate, 3/8/1999 to 25/8/2020. He has joined the military.
Yes.
After the 24 days, experience certificate, I got 24 days. He joined
Sorry?
Respondent is joining the army. He got a 24-day, he got an experience certificate. After 24 days, he joined the army. Yes, but
Defense Director. As per defense. Director of General Resettlement, page number 40. Sorry. He says that one complete 15-year service. Notification.
Council, what are you relying on? Page number?
39.
Yes.
Para 2, son.
Hmm.
In the rule 6 of the ex-serviceman, re-employment in a central civil service and propose rules 1/1979 hereinafter referred to as the said rules, after sub-rule 3 of the following sub-rules shall be the inserted, namely, for appointment to any reserved vacancy in a group C post. This is the C post. Motor vehicle inspector post is a C category post. C post, a matriculate ex-serviceman with terms includes as ex-serviceman who has obtained the Indian Army Special Certificate of Education of the corresponding certificate in the Navy or the Air Force, who has put in the not less than 15 years of a service in the armed forces of the Union may be considered eligible for appointment to the post for which the essential educational qualification prescribed in the graduation and where work experience of a technical or professional nature is not essential. Next piece. Though non-technical professional work experience is prescribed as essential, yet the appointing authority is satisfied that the ex-serviceman is expected to perform the duties of the post by undergoing on the job training for short duration. For appointment to the any reserved vacancies, only for reserved ex-servicemen. In Group C and Group D posts, where the prescribed minimum educational qualification is a matriculation, the appointing authority may at his discretion relax the minimum educational qualification in favor of the ex-serviceman who has passed the Indian Army class 1st examination or equivalent examination in the Navy or the Air Force and who has put in the at least 15 years service in the armed forces of the Union and is otherwise considered to fit the hold the post in view of his experience and other qualifications. My lord, one Supreme Court judgment is. Civil Appeal number 5304 of 2008. Observation made in the para 4. Appellant here in National Survey Organization is established under the Department of Statistics of a Government of India, the service condition of its employees who governed by the rules framed by the President of India in exercise in power under the proviso of appended to the Article 309 of the Constitution of India in terms of the said notification amendment had been carried out in ex-serviceman re-employment in a central civil service and post rules of 1979. Rule 6 of the said rules after a sub-rule 3 of the following sub-rules were inserted. For appointment to any reserved vacancies in the Group C post, a matriculate ex-serviceman with terms includes an ex-serviceman who has obtained the Indian Army Special Certificate of Education or the corresponding certificate in the Navy or the Air Force who has put not less than 15 years of the service in the armed forces of Union may be considered eligible for appointment to the post for which the essential education qualification prescribed is graduation and where work experience of the technical or professional nature is not essential. He has got the work experience, 1 year work experience certificate. Though the non-technical professional work experience is prescribed as essential, yet to the appointing authority is satisfied that the ex-serviceman is expected to perform the duties of the post by undergoing on the job training for a short duration. Respondent one is the 15 years completed in the army. He got a 1 year experience certificate.
Yes.
After the rule 6, following the rules inserted, the lower standard or selection in the case of direct recruitment of sufficient number of candidates belonging to the ex-servicemen are not available on the basis of the general standard to fulfill all the vacancies reserved for them In this notification, five ex-servicemen, 2 posts are filled, in 3 posts are vacant. And belonging to the category ex-servicemen may be selected under the relaxed standard of a selection to make up the deficiency in this reserved quota to subject to the condition that relaxation will not affect the level of the performance by such candidates. In this case, respondent is eligible.
Yes.
In this case, respondent is eligible for all kinds of eligibility. There is a no there is a no question of the selection in the KPSC. I appeal that dismiss the writ petition of the KPSC filed against the respondent number 1. Restore the administrative tribunal order.
Yes. You don't have a contention that you have the qualification as prescribed.
Yes.
You don't have the qualification as prescribed.
Well, I have the qualification.
Oh. The qualification, there is a prescribed qualification.
Yes, I have applied the prescribed qualification, the experience certificate as applied.
The contention is that the experience must be one obtained after securing the educational qualification.
My prayer is there. Once I completed the 15 years of service in the army.
Where is that contention?
Reserve for the military and reserve for the ex-serviceman, some relax the appointment authority.
Who has to relax it?
Appointment authority, KPSC has relaxed the appointment.
Therefore,
As means with page number 39, so page number 39, Ministry of
council,
Personnel.
it is for the appointing authority to decide whether any relaxation is called for. If there are not enough qualified persons available.
He is a qualified
up.
person. He is a qualified person.
This contention was not taken up. So I think it's for the first time. And my Leonard Fed is relying upon some central government regulations, which will not have any application. Number 2, my lords, the ex-serviceman reservation is under the general recruitment rules. It's a horizontal reservation, but 10% reservation is given across my lords categories. That's GM, SC, ST. Now, my lords, it also provides how in case it is not filled up, how it has to be operated, whether it is carried forward or whether it will be converted to the pool of the same category. Like if it's a GM ex-serviceman, then it will be converted, my lords, to GM others and all those things. So here, his contention seems to be that some relaxed standards have to be applied. But that was in the context, my lords, relaxed standards comes in the context where there is a general standard, there is a relaxed standards, and further relaxation of the relaxed standards, my lords, for a particular category, which I don't think, my lords, applies. In certain recruitments, my lords, percentile is fixed as a standard, as a general standard for the purpose, and then there will be relaxed standards, my lords, for a category candidate. But I don't think even they have not raised this contention. The tribunal has just gone about only on the premise that he has the experience. And his case is that, and the tribunal has also said you have to fit him in the select list, as if he has the experience at a particular seniority based on his marks. Operative portion of that order of the tribunal, my lords, is very clear about it. And if according to me there is anything, my lords, it is a question of giving a representation to the appointing authority if vacancies are left out. That is a separate remedy.
Yes.
Please. My lord, annexed page number 275, page number 270.
Yes.
Respondent has completed the degree, course May 2019. May 1999.
When was the result declared?
24th December.
Yes. What was your contention before the tribunal in the application?
Page 21. My lord, kindly see the page. Para 6, the applicant has obtained the diploma in automobile engineering 3 years duration in the year 1999. He has obtained the experience certificate from Mrs. Jagadamba Automobiles from period from 3/8/1999 to 25/8/99, which experience is a more than 1 year is required in the recruitment notification. The contention of the respondent KPSC para 11 of the replay statement is a DRS, the recruitment notification, there is a no requirement of a 2 years stipulated service period. Also, the averment during the hearing in which a completely adds odds with the para 11 of the replay statement that the applicant obtained the service experience prior to the obtaining of the academic qualification is also untenable on facts.
Counsel, you admit that your qualification was only on 24/12. What is the date when you acquired the 24/12/1999? Therefore, it was only thereafter that the qualification can be, the experience can be counted. From then, you have experience only till 25/8/2000.
Yes.
All these are facts.
Yes.
If that is so, you do not complete the 1 year qualification.
My
Else is with the appointing authority. If you have any such contention that you are entitled to it.
my prayer is the honorable court may kindly see may kindly consider for my my degree is date May in 1919 in the year of 1999.
24/12/1999.
So sorry, 24 May. Sorry, 24/10. May in course completed May 1990.
Not help you unless you pass the examination. How are you?
Complete up 24 December 1999.
Correct. 24th December 1999.
Yes.
From then, you must have 1 year's experience.
Yes.
You don't have a contention that you have 1 year experience after 24/12/99. This is the fact.
Yes.
Therefore, this finding of the tribunal is wrong. If in every case, the qualification is to be, experience is to be reckoned after acquiring the basic qualification, then the finding of the tribunal is wrong.
My prayer is there. Once I completed a 15 years of service in the army.
That is for the appointing authority to consider. If you are entitled to any relaxation is not the question here. What you pleaded before the tribunal is that you are qualified. The tribunal held you are qualified. This court in this judgment appears to have affirmed the position that persons who acquire the experience qualification before the date of acquisition of the basic qualification will not be entitled. That appears to be affirmed by this court in this batch of petitions. And therefore, you can count the qualification only after 24/12/99.
Yes, my lord. In this
Then you
case,
don't have the qualification.
in
Now,
this-
everything else, you may have to take it up with the appointing authority, not the PSC. The list cannot be tinkered with.
Yes, my lord. In this case, 5 reserve post in the ex-serviceman, not general. In reserve, my prayer is there. Ex-servicemen, at least some relaxation for the as per the.
That how can the PSC do it? PSC is the selecting authority. Whatever condition they provide, it has to be provided across the board to everybody. Only for you, they cannot have another criteria.
In this case, respondent is a ex-serviceman, is a reserve for the ex-serviceman post.
Where have you raised the contention that you're entitled to reservation before them? Even before the tribunal?
Ex-serviceman.
There is the.
In the paragraph number 9, India will be captured. It is the contention of the service period requested a minimum of 2 years. If the reference is to the period of diploma, it is not in dispute that applicant has a 3-year diploma from the Board of Technical Education as to say in the recruitment notification and further a 1-year experience.
This is wrong. Something is wrong because the 1-year experience is to be after the acquisition of the diploma. Diploma is acquired only when 24 years. This statement refers to that. You've not raised any such contention. And this court appears to have.
Not only that. In a subsequent, thereafter, my lords, the list was revised on the basis of this list. That was also challenged in the KSAT. And my lords, in the second round of litigation also, it has, division bench, my lords, has also again reiterated the affidavits have been extracted and then dismissed those petitions. I'll just pass on that also. So it is 2 division bench orders.
There cannot be a separate rule for one person. Question about that. In a selection, if a rule with regard to experience has to be for across the board. Otherwise, your remedy would be to make a representation seeking some relaxation from the appointing authority, not in this fashion.
It's para 10. We, on the basis of the earlier judgment, we implemented that, my lords, and a new list was published. Then that list was challenged and then tribunal had dismissed the petitions. Then at para 10, my lords, based on the submission by the advocates, the following questions. Whether the KPSC had followed the direction of this court passed in WP number 64774 of 2020, whether withdrawal of the select list, which was earlier, and publication of the new list is bad in law, whether the impugned order calls for any interference. Now, my lords, in this, they extract the earlier operative portion at para 11, and my lords, in para 13, the affidavit that was referred to earlier, my lords, is also extracted here at para 13, the affidavit of the Public Service Commission. At page 14, my lords, in the second para, that affidavit states that is what the state government had said, that by the recruitment notification, the commission invited applications and clarification was sought by the commission about acceptance certificates and only those people who have acquired the working prior to.
Yes, that all the experience certificates produced by the candidates be treated as sufficient, subject to fulfillment of other eligibility conditions and exclusion of experience certificates produced by 16 candidates who, as per the certificates produced by them, have acquired the working experience prior to their acquiring academic qualifications stipulated. And therefore, if you are to be given, those 16 also have to be considered. This is the rule of selection that they have followed. It cannot be.
And then, my lords, finally, the court had dismissed the petitions.
In our considered opinion, there is no breach of any condition issued by this court by the KPSC as strenuously contended by the petitioners. There was no contention before the tribunal that there were not enough candidates in the list of ex-servicemen. We don't know. Probably there are several who would have been otherwise eligible if this condition had been given a go by. We don't know. Yes, who appears for R4? Hmm.
The business want did not have the requisite work experience, that's why candidates are rejected regularly.
Yes.
I have been already appointed and I am.
You are also an ex-serviceman.
Yes, ma'am.
There are other persons also below you in the list? You don't know.
Only 2 candidates are selected, ex-servicemen. 3/4 are vacant.
We'll say that in case he has any.
Any other
contention,
claim on the basis of relaxation, he can approach the with that
the appointing authority.
appointing authority.
No. Only 3 persons are applying the post. Remaining 2 are,
They cannot do anything, council. They have to go by a set of rules which must be uniform for everyone. If this contention of yours is accepted, then there are 16 others who have the very same kind of certificates. They will also have to be considered. There may be others who did not apply because of this condition. They may have had qualifications prior to their 1 year's experience prior to their qualification. They could also have how do we know that there were no ex-servicemen in that? There could have been other ex-servicemen who had the qualification, the experience qualification before acquiring the diploma. They did not apply because there was a
only 3
condition.
candidates are applied, my lord. Only 3 candidates applied the post.
Exactly, council. It could have been because they did not have the qualification as provided. The 1 year's experience they did not have after acquiring the qualification of basic qualification. You don't know. They cannot do anything. They have to conduct it in accordance with whatever is the condition they are prescribing. It must be the same across the board.
My,
If you have any contention with regard to relaxation, you will have to approach is the government a party here?
my prayer is,
Yes, it's a formal.
my prayer is the ex-serviceman is expected to perform the post of undergoing all the job in service. There is some relaxation.
All that cannot be considered in a selection. The selection has to go by the rules of the selection as provided in the notification. The notification says 1 year experience. 1 year experience is taken from the date of acquisition of the qualification. That procedure appears to have been approved by 2 bench decisions of this court. The tribunal cannot go over that. The tribunal apparently has not considered this contention. Was the contention raised specifically?
With regard to relaxation,
No. The contention that it has to be after the.
it was,
acquisition.
my lords, what the tribunal says is, the tribunal assumes that he has a qualification. And in fact, that diploma certificate was not produced by him before the tribunal. We have produced it, my lords, as an additional document.
That's the end of it.
We have produced. Before the tribunal, it was not before the tribunal.
Completed in a 24.
Yes, 24 December 1980. After that, it has
My lords,
been
we have
happening.
produced it along with the writ petition.
Prior to obtaining this certificate, before this.
All these
Only after obtaining degree,
Correct. All the
1 year
16 candidates
service.
whose experience was before have been rejected. It has been approved by the bench decision of this court.
My lord, my prayer is the exemption of the ex-serviceman. It is.
There is no such prayer, council. We are sorry to say there is no such prayer. Absolutely nothing before the tribunal. Even before this court, there is nothing. You are producing this for the first time. No such contention. After the entire selection has been approved in the year 2021, when did you file this
Notes, reject list.
application? When did you file it?
Notes, reject list was in 2016.
Hmm.
February 4 to 2016 was a reject list that was challenged. 27/3/23, he files the petition, original application. And in the meantime, 2 rounds of litigation also that I referred to by the other candidates.
After this very question of experience had been settled by this court, how could you have raised it before the tribunal itself? Was there a delay petition?
Delay ಹಾಕಿದ್ದಾನೆ?
He has
Delay
completed his final
year.
examination on May 1999. He has obtained this certificate on 24th. This is after. Final examination held in the month of May in the year 1999. Result is, he has completed diploma on 24. Examination, after completion of examination, he has obtained the certificate.
Let's, insofar as that thing,
Yes.
please,
There's an interim order.
there is.
Yes, learn, data, please get instructions. The interim order shall continue.
Please.
Fourth September. Passed over matters. 7, government advocate.
This is a matter regarding the earned leave encashment minutes and the component of DA. Minutes, insofar as the position minutes we have verified.
Yes.
Since in the state, we have not been paying interest minutes on DA component at any point in time. The argument minutes that I want to advance is limited to the fact that whether in a contempt proceedings, minutes the tribunal could have gone into this question minutes is what I'm submitting. Let's kindly see the order that was passed
Yes.
at page number 26, the operative portion minutes of the order of which, we're sorry minutes for the small copy.
That is all.
Please minutes. Page 26 minutes. The application is hereby allowed. The respondents are hereby directed, in particular, the third respondent is directed to consider the representation dated 9/8/2017 as per annexion A9 and to settle the retirement benefits of the applicant such as DCRG, CVP, computed value of pension, leave salary and other benefits which the applicant is legally entitled to, along with admissible interest from 1/6/2016 onwards till the payment of the entire benefits of the applicant. 1/6/2016 minutes is the date of superannuation. So
Admissible interest is the,
admissible interest, along with admissible interest, and my lords, my emphasis also is on the third line of the direction, that is consider the representation and to settle and along with admissible interest is what we are saying.
yes.
Now, my lords, according to us, we have the first compliance affidavit that was filed is at page number 159, my lords.
Yes.
At 160,
Hmm.
para 4,
Hmm.
they have extracted para 4. I respectfully submit that it is relevant to mention here that there was an audit objection against the applicant stating that the applicant has violated KTPP Act. The applicant is liable to pay rupees 2,01,763 and that amount has to be credited to the government. In this connection, it is submitted that the applicant herein has also filed a separate application number so and so against the letter dated 4/9/2019, wherein it is stated that an amount of rupees 2,01,763 has to be deducted from the bank of the applicant and the same has to be credited to the government. Accordingly, amount of rupees 2,01,763 has been withheld from DCRG of the applicant and resultantly pensionary benefits of the applicant have been settled by the Office of the Accountant General by the order dated 25/11/2019. A true copy of the order dated 25 so and so. I respectfully submit that thereafter on 2/11/2020, an official memorandum was issued by the Office of the Treasury, Bangalore, sanctioning interest amount of rupees 3,68,653 towards 7,098, 7,98,273 of DCRG amount and rupees 6,56,965 amount of terminal leave encashment. A copy of so-and-so is produced. I respectfully submit that thereafter the authority has issued an endorsement on 23/3/2022, and in the said endorsement, all the relevant facts have been stated, and that except for 2,01,763, all the benefits have been released in favor of the applicant as directed by the Honorable Tribunal. Insofar as the said amount of rupees 2 lakh so-and-so is concerned, there is reasons for not paying the same as have already been stated above. The said amount is due by the applicant towards the government, and separate communication dated 4/9/2019 has been issued by the authority to deduct the said amount, and the said communication has been assailed by the applicant in a separate application number so-and-so. A true copy of the letter. Hence, for the previously mentioned facts and circumstances, the authority has fully complied. The order passed by this Honorable Tribunal may kindly be dropped, closed. Now kindly see page 163, my lords. 163, my lords, what we have done is, my lords, provisional pension was already paid. In this, my lords, at serial number 2, his DCRG, my lords, was fixed at 10 lakhs. Out of that, my lords, 2 lakhs was withheld and 7 lakhs odd was paid and interest was paid on that. Then, my lords, insofar as the then revised commutation and other things took place, my lords, and 2,01,000 was withheld. Thereafter, my lords, in the next page, my lords, I'm sorry, we don't have English translation, but I'll just below the subject, my lords, we have one paragraph. 8% interest is there, my lords. 8% interest. The calculation was sanctioned. My lords, the serial number 1 relates to DCRG. That is DCRG. It was from 1/9/2016 to 31/9/2016 interest amount. Principal amount was this and interest amount was paid to this. The second one, my lords, is leave encashment. Amount, interest period was mentioned and the amount was mentioned at 6,56,956 and interest of this was paid. This amount was paid to him, and my lords, thereafter an endorsement was issued at annexure 160 at page 165. And my lords, we had explained all these things, what was stated in the compliance affidavit. Now, my lords, thereafter the tribunal at page number 169, 168 and at 169 close the contempt proceedings. He filed an application, my lords, for recalling, which is at page 160, 172, and my lords, which was allowed, and the petition was restored back, and we filed an additional compliance affidavit at page 180. In the additional compliance affidavit, my lords, at paragraph number 4, we have stated, may I read, my lords, at page 181. I respectfully submitted in the earlier compliance affidavit filed before this Honorable Tribunal, a submission was made that 2 lakh so-and-so was withheld from DCRG of the complainant. But thereafter, the said withheld amount was released. We released that also by the Office of the Accountant General on 1/2/2013 in pursuance of the permission given by the government. Copy of the authorization issued by so-and-so is produced. Further, it is submitted that the amount of rupees 9,98,000 so-and-so has been paid as interest amount to the complainant towards the withheld amount of so-and-so. Hence, it is submitted that the orders of this Honorable Tribunal have been fully complied with. Just pausing here, my lord. So, entire DCRG was 10 lakhs. Withheld amount in the additional compliance that also was paid. Now, para 5, my lords, is the issue. I respectfully submit that the complainant submits that the payment of interest for terminal leave encashment amount of rupees 14 lakhs. So, this may be marked, my lords. Total terminal leave we paid was 14 lakhs. Has not been fully complied as interest for the sum of rupees so-and-so has not been considered for the calculation and accordingly submits, this is his contention, submits that interest of so-and-so has not been paid. In this connection, this is our statement. I respectfully submit that interest for terminal leave encashment has been paid to the complainant as per the direction given by the government in its letter dated 3/3/2020, wherein a clause 2, a direction has been given by relying upon the government circular dated 2/9/2024 to calculate interest without considering D amount, and accordingly DA component in terminal leave encashment amount to rupees 8 lakh so-and-so was not considered for interest. Copy of the government letter dated so-and-so is produced. By not considering D amount of rupees so-and-so, interest was calculated for 6,56,965 and accordingly interest amount of rupees 1,66,432 has been paid to the complainant. In view of the same, I submit that the complainant has been paid interest amount for delay in payment terminal leave encashment as per his entitlement. So, my lords, what we are saying is this. Now, I will, my lords,
Then what happened?
Then, my lords, the tribunal at page 193, order starts, my lords, at 191. 193 may kindly be seen. They have considered extracted at 192 our entire additional counter affidavit compliance, and I'll read para 3, my lords. We have considered the rival contentions. The leave encashment benefit. This is what I'm saying, my lords, could not have been done in a contempt proceedings. The leave encashment benefit includes DA component on the salary component of the benefit.
Hmm.
The entire leave salary encashment benefit has been delayed and not just the salary component of the leave encashment benefits.
Hmm.
Therefore, the contention of the accused that no interest is payable on the DA component is untenable, and the logic of not paying interest on the DA component, which is also payable along with the salary component of the leave encashment benefit, is unintelligible, indeed illogical. The accused is therefore remiss in not paying the interest on the DA component of rupees so and so, along with the interest amount paid on the balance component of DA that has undisputedly already been paid. The complaint is estimated at rupees so and so, but that amount would have been varied since we hold that the interest amount on DA component of leave salary encashment is also payable and the interest is to be calculated until paid. Now, my lords, my submission is this. This finding in para number 3 could not have been given in a contempt proceedings. My lords, I will just pass on, my lords, one judgment of the Supreme Court for this reason.
Difficult.
Please, my lords.
It says admissible interest. When you say admissible interest,
Please, my lords.
what would be, you don't say that it is not payable.
We are saying that, my lords. Now we are,
You're not saying that the amount was not payable.
please, my lords.
You're also not relying on anything except one letter.
One letter. I will show that letter. My lords, that is the only letter. And also, my lords, we have verified. Now, my lords, similar compliance affidavits were filed in several of the matters, my lords, with regard to Collegiate Education Department, and also we have consulted the Finance Department on the DA component. For example, my lords, I'll put it this way. When pension is delayed, let us assume pension is delayed, pension is fixed. Now, my lords, if there is a delay in payment of the pension, now, my lords, the interest is always the 8% interest. Now we have reduced it, my lords. Earlier it was 12% in between. Interest also is what the state government itself has decided. That is as per state government extant circulars. Interest is what we have decided, my lords, at 8% during that point in time. Now, on what it was payable also has been provided. We have specifically excluded the DA component. I will give an example, my lords. When pension is fixed, for example, in this case, it was fixed at 39,990 or 40,000 rupees. Now, that is a pension if there is any delay on that. Now, apart from that, under the pension rules, at the time of, there is a separate DA component also. We have not been paying interest component insofar as the DA is concerned, my lords, at any point in time. What my submission is, that is an issue that requires to be decided in a properly constituted petition. And in a contempt proceedings, my lords, a finding that has been given by the court is going beyond that, because prima facie, I'm showing a material which says that the state is not considering DA, and it is not that I'm making a statement, my lords. It's not that only in this case. I have precedent where we across board, my lords, this kind of my lords, we have.
Let my friend consider only with reference to the facts of my case. Let him not consider what has happened before the tribunal and what is going on there.
Lords, what we are submitting is on DA. In our state, my lords, we have not been paying, my lords, for delayed payment. Maybe.
What is the logic behind?
Lords, the logic behind.
He would be entitled to payment of pension as well as whatever component he's entitled.
Lords, the dear it's an allowance. It's an allowance that has been granted. It's a dearness allowance. It is not included in the pay component. Now, under the definition of pay also, my lords, on the KCSR, that allowance is not included. It is not included, my lords, in the definition of pay. My lords, therefore, my submission, my lords, is in a contempt proceedings, a finding that has been given, my lords, in paragraph number 3. Those findings, my lords, at least for the purpose of it is necessary to be adjudicated in a properly constituted. If that finding has to be given, that the policy of the state in so far as denying DA interest on DA component, my lords, is arbitrary or not fair, has to be in a properly constituted petition, is my respectful submission. In the contempt proceedings, my lords, could they have been, I've issued an endorsement. Now, according to that, we have denied it. And I'm making a statement, my lords, that we are not paying, the state is not paying on the dearness allowance any interest. Just I gave an example. 40,000, my lords, will be the pension that will be fixed on the basis of his last drawn pay. On the basis that I've just shown the pay slip. In that, it says 39,990 has been fixed, and commuted value, my lords, it has become around 12,000 rupees. Now, there is a delay in payment of that amount. I am paying interest only on that amount. The state is not paying interest on the dearness allowance at all. The dearness allowance applicable to a pensioner, my lords, is separate under the pension rules separately. Now, my lords, in the case of earned leave also, insofar as the pay component is concerned, we are paying that allowance. So there is a logic behind that, but that has to be in a properly.
Which is the provision that you rely on for that?
My lords, last time I had passed on the translations, my lords, in one. Put up, sir. Without any memo, itara kottidde nodi. Itara on page 14. I'll pass on, annexure R7, I'll pass on my copy. ಇಲ್ಲ R7. Page 187 is the Kannada version notes. Last time I had passed on the translation of 4 documents in the open court. Translations.
Yes.
My lords have the translation notes.
Hmm.
Lords, in this, we have, my lords, in paragraph number 2, have clarified. The department, it has received the proposal from the secretary with regard to payment of interest in such kind of proposals. FD internal section has observed and examined by observing the below details and has given opinion in concurrence of it. Now we have, my lords, given this, given the points.
Hmm.
We have said, number 1, interest should be calculated on the changing rate of interest as and when it has changed. And on the right side, we have stated what are the points. Now, 2, my lords, that is what we are saying. Interest payment will not be applicable on dearness allowance. This is what we are saying. And right side, my lords, is a explanation to that. But in the state, it is not admissible is what we are saying. Whether the fact that it is inadmissible is illegal is the second aspect. Notes in the 187, there's a Kannada version, my lords, the original 187 mechanics. For
189 English version.
okay. Okay. ಹೌದಾ ಅಲ್ಲ ಒರಿಜಿನಲ್ ವರ್ಷನ್ ನೋಟ್ಸ್ ಇನ್ 187 ಕನ್ನಡ ವರ್ಷನ್ ಅಲ್ಲಿ ಬಾಟಮ್ ಆಫ್ ದ ಪೇಜ್ ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಬಡ್ಡಿ ಪಾವತಿಯು ತುಟಿ ಭತ್ಯೆಗೆ ಅನ್ವಯವಾಗುವುದಿಲ್ಲ.
Does not include the pension.
Yes.
Notes, so therefore, in a contempt proceedings or in a petition, my lords, arising out of a contempt proceedings, my lords, the fact, my lords, that the dearness, interest on dearness allowance is inadmissible, or it is illegal, could not have been gone into, my lords, is my respectful submission.
Yes.
My lords, in support of that contention, I am placing reliance, my lords, on decision of the Supreme Court, 2014, 3 SCC 373, Sudhir Yadav's case, my lords.
Yes.
Para 19.
Yes.
This is para 19 minutes, I'll just read. The merit,
Yes.
the power vested in the high courts, as well as this court to punish for contempt is a special and rare power available both under the Constitution as well as the Contempt of Courts Act. It's a drastic power which, if misdirected, could even curb the liberty of the individual charged with the commission of contempt. The very nature of the power casts a sacred duty in the courts to exercise the same with the greatest of care and caution. It is also necessary, as and more often than not, adjudication of the contempt plea involves a process of self-determination of the sweep, meaning, and effect of the order in respect of which disobedience is alleged. The courts must not travel therefore travel beyond the four corners of the order which is alleged to have been flouted, or enter into questions that have not been dealt with or decided in the judgment, or the order violation of which is alleged, only such directions which are explicit in the judgment or order or are plainly self-evident ought to be taken into account for the purpose of consideration as to whether there has been any disobedience or willful violation of the same. Decided issues cannot be reopened, nor can the plea of equities be considered. The courts must also ensure that while considering contempt plea, the power available to the court in other corrective jurisdictions like review or appeal is not trenched upon. No order or direction supplemental to what has been already expressed should be issued by the court while exercising jurisdiction in the domain of contempt law. Such an exercise is more appropriate in other jurisdictions vested in the court as noticed above. The above principles would appear to be cumulative outcome of the precedent cited at the bar, namely so and so. So therefore, my lords, my submission is
Yes.
the operative portion, my lords, was very clear. Consider his representations, pay allowances along with admissible interest. The stand of the state is on dearness allowance, we are not paying any interest. For the rest of the thing, we are paying the interest. So the fact, but the tribunal, my lords, has considered, has in fact given a finding in para 3 that it is unintelligible and and so that could not have been done, my lords, in a contempt proceedings, nor in this proceedings before my lords. My respectful submission is that was the policy of the state. It might not prima facie also appeal to the court, but my respectful submission is in these proceedings, a finding cannot be given that it is not admissible. According to whatever is admissible allowance, what is admissible has not been decided. If according to them, now endorsement has been issued specifically stating that we are not paying interest on dearness allowance. He can challenge that circular also has been produced, has also been furnished to him. He can challenge that letter or circular, whatever has been issued, and that provision, and also, my lords, seek for a declaration that interest is payable. Then, my lords, at that point in time, the state will be able to defend its policy, and it is at that stage, my lords, it arises. Therefore,
the submission is, so facts are
Yes.
facts remains undisputed, my lord, that I'm a retired principal of the government college. I retired until 2016. My pension and benefit, nothing has been paid, my lord, that ultimately, I went to the court, my lord, the matter was adjudicated. Ultimately, was decided, my lord, page number 140, 154, 153, the operative portion of the orders of the tribunal. You will also kindly see that the application is hereby allowed. The respondents are hereby directed, in particular, the third respondent is directed to consider the representation and settle all the retirement benefits of the applicant, such as DCRG, CVP, pension, leave salary, and other benefits which the applicant is legally entitled to, along with admissible interest from 1/1/2016 onwards. Now, this order remains unchallenged. They admit that. They admit the fact that they are the delay on the part of settling the accounts. They paid everything. What is paid is leave salary also paid. While paying the leave salary, only they paid the pay, the interest is not paid. You will also may kindly refer to Rule 118 of KCSR. Rule 118, capital A. Capital A.
Yes.
Whether leave salary is a retirement benefit or not leave pay. What is prescribed is under 118 is leave salary. Your lordship is well aware, a salary includes a pay. Salary includes pay, dearness allowance, CCA city compensatory allowance, other allowances which is all admissible. That is called salary. My friend is arguing without noting the difference between pay and salary. Salary includes pay and other allowances. What is legal pay is on 118A, where a government servant retires on attaining the normal age of retirement under the terms and conditions governing service. the authority competent to grant leave shall suo motu grant cash equivalent to leave salary for the earned leave. Cash equivalent to earned leave, if any, at the credit of the government servant on the date of the on date of his retirement, subject to the maximum 300 days. So what is mandated under 118 is that the authority competent to grant has to pay the leave salary, not the leave pay.
Yes,
No, not how the leave salary has to be calculated.
yes.
That is provided in sub rule 3 of rule 11 and 118. You will also make kindly.
Yes,
Kindly refer to sub rule 3 of rule 118.
yes,
The cash equivalent to equivalent and subsection sub rule 1 shall be calculated as follows and shall be payable in one lump sum as a one-time settlement. No house rent allowance or city comfort allowance shall be payable. How it is to be calculated? Cash equivalent, then basic pay admissible on the rate of retirement plus dearness allowance admissible thereon on the day. Now, what are they paid? That the basic pay of the leave salary paid, they pay the interest also. What is not paid is the allowance admissible. They say that DA is not allowable. When the rule itself categorically, a rule framed under Article 309 of the Constitution or under the Karnataka Civil Services Act itself specifically prescribes how a leave salary has to be paid, can they rely upon a circular when the rule provides or a circular, not even a GO under Article 162 of the Constitution? What is can they rely upon that? Even that is also not that. What is referred on page 187 of my report, that is only DA is not payable, interest is not payable. Leave salary is not there. That is not what that circular has nothing to do with the issue on hand. So therefore, my submission is that what is the tribunal directed? We pay the leave salary also along with all the admissible interest. Leave salary, they pay the how the leave salary has to be calculated. It is specifically and categorically provided under sub rule 3 of rule 1118 capital A. So therefore, no matter one lump sum it has been, if it has been paid, it has been paid. If the salary is paid, not kept that amount in the bank also, I am not entitled for interest. They admit the fact that it's a delay. They paid everything. But they say that we will not pay salary, we will not pay interest on the dearness allowance. How the
what do you say about this contention that it cannot be considered in a contempt proceeding?
No, content. Well, they've gone into there is a leave, pay the leave salary also. Leave, how the leave, therefore I'm confining refer to rule 1118A. What is directed, you pay the leave salary also along with interest. While you are paying the leave salary, can they confine themselves only paying to the pay excluding the dearness allowance? That is the question which arises for large kind consideration. Leave salary has to be paid in one lump sum. How it is to be calculated? Pay plus dearness allowance. That must be paid one lump sum. Therefore, at the time of paying the pay, can you delete that note? You are entitled for pay only, not pay. Therefore, my submission, you lost with that salary includes pay and other allowances. Therefore, issue the sovereign judge. Therefore, I am entitled for interest, not that which has been held, that order remains unchallenged.
Yes.
Therefore, my humble submission to you also that salary includes pay. Salary is a larger component. Pay is one of the components of leave salary.
Yes.
Therefore, they cannot deny the fact, and having admitted the fact that there is a delay in payment of the leave salary, they cannot say no, we will pay only interest on the pay, not on the dearness allowance, which includes salary. That cannot be sustained. That then the sober of the in support of my contention, that if there is a delay, whether that carries an interest or not. I place reliance upon judgment of this Honorable Supreme Court, reported in 2012 for SEC, page 6 to 7, para 13 may be kindly be please. Paragraph 13. Report judgment, ವಯಸ್ಸಾದವರು ನಮ್ಗೆ ವಯಸ್ಸಾದವರು ನಿಮ್ಗೆ ಅಂತ ಹೇಳ್ತಾರೆ. Report judgment. ವಯಸ್ಸಾದವರು ನಮ್ಮ judgment ಕೇಳ್ತಿದ್ರು.
ವಯಸ್ಸಾದ್ರೆ ಜಜ್ಮೆಂಟ್ ಕೊಡ್ಬಾರ್ದ?
Report the judgment, sir. Now, so far, the para 13 not pretty. They admit the delay. They don't deny the fact. They paid the everything. Paragraph 13 may be kindly be perused.
What is paragraph 13?
Paragraph 13.
In view of the above discussions for the reasons stated above, present appeal succeeds.
If there is having admitted the delay, that if there is a delay in the payment, admitted that they have to pay the interest.
What is the discussion, counsel?
I'm sorry, it seemed sorry, we don't have a copy of that put outside. I have only 2 copies there. If I'm handicapped, extremely kindly, bear with me, please.
He says in view of the above discussion,
The-
the reasons stated.
Yes, sir,
above,
that's,
that
so
succeeds.
they are admitted.
The order passed by division bench of the High Court and that of learned single judge denying interest on delayed payment of retirement benefits. What looking to state?
What I'm telling you, if there is a delay, that it may,
Not the question that is being addressed. The question that is being addressed is payment of interest on the ground that they say, rightly
yes,
or wrongly. Should it be challenged in the, should those proceedings be challenged?
I
is the
have not,
question.
I have not challenged. What is challenged is that.
Exactly. Therefore, the contention that is now being, that is the only argument they're raising.
Is,
The contempt, it cannot be done.
it cannot be gone. That for that, Manoj, he.
Answer that.
No, the court has not gone beyond the orders. While exercising the power of under section 17, the power of contempt under that act, where do they gone out? They said that pay leave salary along with interest. Have they paid along with interest? No, that was that. You are, so the contention what my place reliance upon that, the court must not therefore travel beyond for 4 corners. Did they gone beyond the corners, 4 corners, within the corners? I have done.
It is for you to answer, not for you to ask questions to the court. Please
My,
answer.
my submission to the honorable case, it did not go beyond it acted well within its own direction. It directed pay the leave salary along with the interest.
Yes.
So therefore, my submission is that the direction of the honorable tribunal, that is challenge is the undeservedly is just proper and correct. It requires to be sustained. Now the circular what my friend read has nothing to do with the supplication. That whether what is clarification, one clarification which is sought is that whether DA carries interest or not. That is all. Whereas in my case, whether leave salary carries interest, that is not the clarification given in the circular. My friend placed reliance upon some other circular for that purpose. That has nothing to do with this. Even otherwise, not that when the rules occupy the rule, a rule framed under Article 309 occupy the field, a circular or a GO cannot take precedence. Therefore, my humble submission, Lordship, is that the orders of the Honorable Tribunal is required to be sustained. It does not travel even 1 inch out of that order.
Yes.
2 clarifications. One is, it is not with interest, it is with admissible interest. What is admissible or not has not been decided, is yet to be decided. We have saying that on DA it is not admissible. And what Rule 118A says how the end leave encashment has to be calculated. It does not talk about cases or does not talk about interest. Interest is only governed by Milord's rules and circulars. Therefore, Milord's 1183 is only about calculation of the earned leave encashment, which has already been paid. Admissible interest is in terms of extant circulars. Grateful.
Yes. Is a-
11. You Anil Kumar, hearing an aye.
Yes,
On merits,
posting of videos.
but both the applicant, the petitioner and respondent number 4 are in the care of PDOs. Not on 7/3/2023, the petitioner has been posted in place of respondent number 4. He reported on 10/3/2023. The fourth respondent, my lord, has ended over charge on 20th/3/2023.
Yes,
Lord, the transfer order has been implemented. He did not question that order. He reported before the Jilla Panchayat for further posting. After 3 months, my lord, he has filed application only challenging the reposting order on 8/3/2023. I filed, my lord, objection to that. The original order has not been questioned. Therefore, application is not maintained. Subsequently, they have filed application for amendment. Thereafter, my case also premature. That application was pending before the tribunal, my lords. The government has again brought back the fourth respondent in place of the petitioner. That is also questioned before the tribunal, saying that my transfer is premature. After hearing the matter, my lord, tribunal has held that earlier the fourth respondent transfer itself is premature. Therefore, my lord, the allow the application of the fourth respondent and application filed by the petitioner has been dismissed, my lord. Lord, Annexure A, page 21 is the order of the tribunal. Only on the finding, my lord, on the ground that the fourth respondent is entitled to challenge the after reporting also. I have no, my lord, insofar as dispute is concerned, he can question the order of transfer immediately after handing over charge to that. But he has challenged the order of transfer after later than 3 months, my lord. Page 51 of the order, the Honorable KAT has referred the judgment, reported judgment of this Honorable Court, my lord, ILR 2013 KR 4564. Only on this ground, my lord, my application is dismissed. The application filed by the fourth respondent has been allowed.
yes,
Lord, in paragraph 54 of the judgment, my lord, in the other case, the tribunal has declined to grant the relief to the petitioner on the ground that the second respondent has taken charge. Here, we would like to point out that a new service jurisprudence appears to have evolved over the years of this regard. The parties, advocates, and sometimes the judges also thinks in terms of that if the person transferred goes to the post, which is transferred and takes charge, then the court's power to set aside the order of transfer does not exist. In my case, in this case, my lord, even on next day itself, he questioned the order of transfer.
yes,
In this particular case, my lord, after 6 months, my lord, he questioned the order of transfer.
yes,
Therefore, my lord, my transfer is premature. He cannot, my lord, brought back to the same place. Annexure A1, my lord, is the order of page 68, my lord. On 8/3/2023, my lord, the order of first transfer. Gangaram, my lord, the serial number 3 was posted to Kannur Gram Panchayat. Insofar, fourth respondent is directed to report for duty for further posting. Accordingly, my lord, he reported and seeking posting also, my lord, as per Annexure A3. Page, my lord, Annexure, page 81, my lord, Annexure R4, my lord. The fourth respondent, my lord, himself has handed over charge. Entire charge, my lord, has been handed over.
when,
This, Lord, on 20th/3/2023, my lord. Subsequently, my lord, during the pendency of the application, page 102, my lord, Annexure A6 and
when
11.
was the application filed?
Lord, the fourth respondent, my lord, after 3 months, my lord, on 27/6, my lord, 2023. my lord. The earlier transfer order is on 7/3/2023.
First order is annexure A2.
A2. In 2 application has been filed before the KAT.
On 8/3/2023 is the reposting order. 7/3/2023 is the order of the government. During the pendency of the application, annexure A 6 month, page 102. Page, relevant page is, my lord, 103. Serial number 10, my lord. One Sri Muni Chikkaya is the fourth respondent. Was posted in place of applicant without showing the name of the, my lord, petitioner also. Again, he brought back to the same place. This was, my lord, even not approved by the Honorable Chief Minister also.
A6 is dated.
Is, my lord,
11/9/2020.
11/9/2023. The tribunal only on the ground that, my lord, there is a 1 year limitation period under section 1921 also Tribunal Act. Therefore, he is entitled to question the order of transfer. My case is concerned, my lord, insofar as he had already handed over charge, he accepted the transfer order. Therefore, my lord, tribunal cannot interfere with the premature transfer of the petitioner also. During the, my lord, admission stage, my lord, this honorable court, my lord, granted an interim order subject to outcome of the petition. This writ petition was admitted.
Yes, this is both within the same district.
Same district.
May I, my lords? My lords, order dated 7/12/2023 by this honorable court, my lords. 7/12/2023. There is a rejection of interim order, my lords, whereas these all the grounds they have taken, which they have canvassed. Here the, my lords, tribunal have allowed our application on the ground that I have been, respondent 4 have been disturbed prematurely. Because, my lords, on the 7/3/2023, the posting of the petitioner in place of respondent 4. It's a premature. Against that, my lords, the respondent 4 have been challenged before the tribunal. That is in application number 2625 of 2023. Respondent 4 challenged, my lords. Thereafter, my lords, during pendency of the application, my lords, I have been brought back to my place, rectifying that the transfer is a premature. That is why the order of 11/9/2023 has been passed. And I have filed a memo also, my lords, with regard to saying that in view of continuation in the earlier place, my lords, I have been brought back, my lords, because my disturbing to that particular place, my lords, is a premature.
Where is this place? 11/9/23, where have you brought to?
11/9/2023 issued wherein the said notification 216 PDOs, my lords. In that order, I have been brought again back to my place, my lords. That I have placed a memo. Kannur only, my lords. Earlier, I have been disturbed from the Kannur Gram Panchayat by order 7/3/2023 by the petitioner, my lords. I have challenged before the tribunal, saying that my transfer is a premature in application number 2625 of 2023. Subsequently, that has been rectified and restored my place, my lords. I have placed back to Kannur Gram Panchayat, wide order 11/9/2023. Then, my lords, the petitioner challenged before the tribunal.
11/9/23 order was challenged by you before the tribunal.
Yes, yes. In OA number 4145 of 2023, my lords.
Yes.
2023. The tribunal order, may I take, my lords? Last para, my lords.
Yes.
Conclusion part, my lords. Running page 33. The learned counsel for applicant in page number 32, my lords.
Yes.
33, my lords. That being the position, the case have to be considered by the considering the validity of the order dated 7/3/2023 and based on the application filed challenging the order 11/9/2023 has to be considered. Page number, running page 33, my lords.
In
KT order, my lords.
53 page number.
Impugned order, my lords.
Petition
Not page
53.
number
53 is the
53, ma'am.
repetition. ma'am.
Internal page number 33.
Page number
Internal 30.
Yes, my lord.
Yes, ma'am.
33.
33.
Judgment, ma'am.
Yes.
33, my lords. That being the position, the case have to be considered by considering the validity of the order dated 7/3/2023 and based on the application file challenging order dated 11/9/2023 has to be considered. Since the earlier order is illegal, consequently reverting him to the earlier position by passing the order dated 11/9/2023 does not call for interference. In view of the said contention and from the records, it clear that application in OA number 4154 of 23 was posted to Kannur Gram Panchayat by order dated 7/3/2023 and reported for duty on 13/3/2023. The said order dated 7/3/2023 is challenged by so and so applicant and challenged the order dated 11/9/2023 on similar grounds that are urged in another application, that the same is a premature, issued without recording reasons and following procedures. Further, it is urged that order passed without providing posting and referred to the decisions. In the view of the fact, the contention rise, it is necessary to consider that the order dated 7/3/2023 issued is in violation of mandatory condition which is necessary to be followed before effecting the premature transfer. As already considered with reference to the facts, provisions and also law declared by the Honorable High Court of Karnataka, the said action is illegal and contrary to the law. As such, the said action is void and ab initio. In view of declaring that the said order is illegal, resultant effect of the same is that earlier position required to be restored. On the restoration, nothing remains in consideration of the order dated 11/9/2023. As the initial order based on which he was posted to the said post becomes illegal, as such consequential reposting order issued is also illegal.
So where does the petitioner go now?
His
I
earlier
have no
place,
posting.
earlier,
Because of this order, I have no posting because
then my lords, the tribunal,
at the instance of
As illegal as the first posting order on 7/3.
Yes, ma'am. That was happening.
This keeps happening.
Yes, ma'am.
This transfers without posting. That is what is causing this entire problem. If in the first place, you pass an order of transfer, giving a posting to the person who's disturbed also, then at least if this happens, he has somewhere to go. Now he is in a limbo. Where does he go?
my lords,
Thereafter, he was
subsequent-
given an order, my lord.
Where?
Madikeri.
Madikeri, that has been,
interdistrict
that
transfer.
was
Mela,
questioned,
That was
that
set
was
aside by the
questioned.
tribunal.
That was also set aside by the
There
KT.
is no provision at all. The posting was given to Madikeri. There is no
Madikeri.
such provision. At the instance of
Yes,
the
my lord,
fourth
that was happened.
respondent, this
My
lord,
lords,
because he
even-
accepted the transfer
He
initially.
accepted the transfer, he is not questioned that. Thereafter, he
After
comes and
6 months,
says,
my lord, he questioned
after
that,
placing
where I have
of him,
to
he
go.
he comes and says that
This
it was
order is
happened like
illegal.
this and all the things.
It is never
He
ending.
is
my lord.
accepted and he is relieved from the duty.
My lords, here at the stage where my lords, even tribunal also directed to government to give the posting to the petitioner. Subsequently, posting has been given. But it is, then again, he has challenged that posting. Now, my lords, he wanted same Kannur place only.
No, no.
That is the
Inside
reason.
district, we
Even
have to give, my lord, we
by
have.
order of this
Madikeri,
court,
that's the
Your
problem.
transfer.
I
When
have
did you first come to Kannur?
Kannur, my lords, 30.
7/3/2020, earlier.
2020
Post is
PDU.
That PDO, my lords.
31,
7/2020. So my
2020.
Yes, my lords.
Now
I am a
your-
verge of retirement.
Now
and
your period is over.
period is over, left out with the 15 months, my lords. As per the guidelines, my lords, whoever within 2 years of retirement, my lords, they have to be continued as per our transfer guidelines. Even old and new also, my lords.
He did
There
not
is-
question the transfer.
No, from Kannur, where were you posted?
I have not been posted. I have been bought.
She has came back. He has
My
came back.
transfer,
When on 7/3.
7/3
Seven-
Jilla Panchayat. my lord.
Jilla Panchayat.
I have not been shown any place at that point of time. That is the reason And looking at the age criteria, my lords, they have restored my transfer, my lords, to Kannur place. Even our statement of objection, we have stated. Now, my lords, anyhow postings
Jilla
are going
Panchayat
on.
was given.
And my lords, if he reports, even in an interim order also, this honorable court directed him to.
On 11/9/23
He'll proceed
order,
to the-
it says, my lord, ten
Chikkam-
serial number 10, Muni Chikkaya, Panchayat Abhivrudhi Adhikari, Jilla Panchayat, Bangalore Nagara Jilla. He has given posting to Jilla Panchayat.
He asked. him to
Thereafter, he has
report
been placed in Kannur Panchayat. The person, the petitioner where he is working.
11/9/2023.
No, no.
No, my lord.
11/9/2023.
That's on
It's
11/9/2023, my lord.
11/9/23, he has been given a posting.
Yes, he has been given posting.
my
It was
lord.
shown, my lord. It was shown in the
That
order.
is under
Serial number 10.
because he has brought back to the same place. That is under question because I am already reported, my lord, on.
So, in
He has given
11,
posting.
He accepted on.
11/9/2023, I have given posting restoring my, to my old place, my lords, Kannur only. He
From
has
the place
been
where
not,
she is, where he is working.
where
He
I
is
have
working,
disturbed
he
my
is
lords
working in
to that place.
Munichikkaya, Panchayat Abhivrudhi Adhikari, PDO, Jilla Panchayat, Bangalore district only.
My lords.
From there
And
to, he has given to Kannur Panchayat, where earlier he was working.
So,
What about the petitioner?
Petitioner
Where is
has,
petitioner?
petitioner has not given the place, my lord.
Yes, I
Thereafter,
am
he
not
was-
shown my name also.
In this place was not given, thereafter Madikeri was given, that was questioned, that was questioned, that was also set aside now.
Now, where will he be posted?
they have to give posting.
There is no posting for him as of,
Has to be given a posting.
So far as my lord.
because of this, we are not taking any decision, my lord.
Please.
Annexure A6, there is no rectification. There is no order of rectification. As said,
We
my
have
lord,
got the
insofar
memo,
fourth
my lord.
respondent has said that there is no such rectification. It was brought back to the same place. Once he accepted the transfer, my lord, it is not never ending. Otherwise, my lord, after 8 months, my transfer
The
also is
tribunal, my
premature.
lords,
That is why, my lord, I am.
specifically stated, my lords.
That is all that you are saying about your order is applicable to the petitioner's order.
Yeah, no,
also.
no, whatever he,
Problem.
my lords, whatever
Yes, my lord.
petition.
You are passing orders without showing
Yes,
postings, which
that's-
is creating
that's-
the
that's what's
entire
happening.
confusion. In all these orders, this is what is done. Somebody is
my-
posting.
No, my lord, respondent, we have given a placement.
My lord.
Petitioner, we have not given. Respondent was placed in the, thereafter, he has been placed into Kannur Panchayat by displacing him, my lord. That was happened.
Earlier, my lords, I
There-
was disturbed. Same thing, my contention, my lords, he has taken, my lords, sir. Because I have pleaded that I have been prematurely transferred. So same contention, later he has taken, my lords.
He has
So that
also-
has been
he has also
rectified.
posted-
My posting is
He can-
rectified and I have been placed in the Kannur Gram Panchayat. But for him, they have not shown the place. Subsequently, coming to this court, my lords, the honorable court directed give him the posting. Then they have given the posting, that to Madikeri, my lord. That order been challenged by the petitioner. So they kept this pending, my lords.
That could not have been granted. The Madikeri posting could not have been granted at that
Like,
point. in time.
even also, my lord,
He-
posting is provided, that is also subject to outcome of this petition, because, my lord, he kept quiet for 6 months.
No, that is
He
earlier.
can challenge,
that-
he
that-
can liberty to challenge immediately after the order of transfer. He kept quiet for 6 months. After
Accepted
6
the
months, he had questioned that order.
Accepted the order.
My
Yeah,
lord,
once it
the
is accepted, he
tribunal-
cannot question
tribunal
that
has
order. my lord.
Specifically
That
stated
is
that
my,
as per the statutory provision, my lord, as per the transfer guidelines, my transfer is premature. That is why, my
Why
lord,
did you not challenge it at the relevant
challenged
time?
I am the first one
When?
who has challenged it. That is 7-3, my lord's order, that is been challenged by respondent 4.
When
During that period, my lords,
27
did you
6
file your challenge?
my lords,
27/6/2023, even only
Even in
challenging the
that-
order of reposting. After filing objection, he filed application for amendment to the challenge after 6 months only on, my lord, 7/8/2023.
here the
Thereafter,
only
he
thing,
filed
my
amendment
lords,
application after
from
6
the
months.
date of 2020.
Please don't speak together.
No, my lords, I'm,
Please, only after one.
yes.
Yes.
My
Nearly
lords,
6
my
months he questioned
contention
the
is,
order.
my lords, if interim order, my lords, which rejected, my lords, in that everything
We're
specific.
hearing it finally.
Yes, ma'am, yes, ma'am. So for the convenience of the court, I am saying, my lords, only thing is, my lords, the contention, whatever the petitioner taking, same contention have been taken by me before the tribunal. So after observing all that, my lords, tribunal found that I have been prematurely transferred. So not to repeat the same thing, my lords, tribunal has elaborately discussed and allowed my application, rejecting his claim and directed government to give place to the petitioner, my lords. Subsequently, my lords, petitioner have been given place, my lords. That also challenged by the petitioner, my lords, after showing the place. But that is now been set aside. Now the petitioner came here saying that still my application pending here. So he wanted, my lords, particular my place, my lords. Here I have completed my tenure, my lords. It's no issue. Only thing, my lords, only 15 months left, my lords. In view of that, my lords, as per the transfer guidelines, I may be continued. I have given a representation. Even, my lords, he also, my lords, given a representation to give the posting. If whatever government take decision, my lords.
Country to please get instructions whether there are vacancies to accommodate
Yes, ma'am.
petitioner immediately somewhere. in the
Insofar as
vicinity.
retirement is concerned, you can provide the posting nearest place, not for continuation after 4 years of tenure.
Let the orders may be passed by the court, my lord.
My lords, may I?
Heard the learned counsel for the petitioner, the learned government advocate appearing for the respondent, as well as learned counsel appearing for the contesting private respondent. It is submitted by the learned counsel for the petitioner that pursuant to a transfer order issued on 7/3/2023, the petitioner was posted to Kannur Gram Panchayat in the place of the private respondent. The private respondent handed over charge on 23/2023, but thereafter, after 3 months, had challenged the order of transfer on 27/6/2023. It is submitted that during the pendency of the said application, an order was passed on 11/9/2023, reposting the private respondent to Kannur Gram Panchayat, rendering the petitioner without orders of posting. Though the order dated 11/9/2023 was also challenged by the petitioner herein, both the applications were heard together and the application filed by the private respondent was allowed, and the application of the petitioner raising identical grounds has been dismissed. It is submitted that as a result, the petitioner is rendered without posting orders. The learned counsel appearing for the private respondent submits that the private respondent had challenged the order dated 8/3/2023 on the ground that she had been disturbed prematurely without showing her a posting, and that the tribunal had considered the contentions and had upheld the order dated 11/9/2023, by which she was brought back to her original place of posting. It is submitted that the petitioner had been granted a posting outside the district which was challenged by him and was set aside.
This is the orders, my lord.
It is therefore contended that the petitioner, that the private respondent is due to retire in 15 months' time, and that she may therefore not be disturbed at this juncture. Full stop. Having considered the contentions advanced, we are of the opinion that the practice of issuing transfer orders disturbing persons prematurely without even showing them places of posting is clearly illegal and against the settled precedents, settled judgments of this court, which have become final. In the above circumstances, we are of the opinion that it is for the official respondents to immediately show the petitioner a place of posting, preferably within the district itself, in view of the fact that the orders under challenge are, in view of the fact that he has been prematurely disturbed from his place of posting on 11/9/2023 without showing him an order of posting. Appropriate order shall be passed within a period of 2 weeks from today.
He has completed his term, my lord.
If
As per the statutory rules, my
they
lord,
have said that the
take the
private
appropriate
decision. Before that, please say that it is submitted by the learning council for the petitioner that the private respondent has completed his term of 4 years in the Kannur Gram Panchayat. Then say that the private respondent. Yes.
as
Appropriate
per
order
the
shall be
transfer
passed.
guidelines, my lord.
Appropriate order shall be passed within 2 weeks from today.
Yes.
Yes.
That's it. Let's, the lordships kindly, that serial number 13 was passed over in the morning at the instance of my learned friend appearing for the petitioner. There's some urgency in the matter. May I humbly persuade your lordship to kindly have it on Monday.
Monday may not be possible. Tuesday.
Tuesday, great. 13th is
Cannot be had on Monday, we are sorry. Yes, please, the postings will be given.
Let's
Serial number 54 on the last.
Court officer? Hello, court officer?
ಹೇಳಿ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 38 ಏನಾಯ್ತು ಅಂತ ಗೊತ್ತಾಗ್ಬೇಕಾಯ್ತು ಮೇಡಮ್. 230 ಮ್ಯಾಟರ್
38 1 week ಸರ್, ಲಾಸ್ಟ್ ಚಾನ್ಸ್.
ಲಾಸ್ಟ್ ಚಾನ್ಸ್ 1 week ಅಂತ ಆಗಿದೆಯಾ? ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.